Là, en fait, la conférence SOAS, sur ces 2 jours, je laisserai la parole après à Dr Onyema d'étaler un peu le programme et le choix fait pour le thème. Mais nous avons de très, très grands spécialistes en la matière, quelques confrères de partout sur le continent, de différentes juridictions, j'allais dire, et de différentes expériences arbitrales sur le continent et d'ailleurs. Nous avons aussi le plaisir d'avoir des internationaux hors continent africain qui nous rejoignent de Paris, de Londres et d'ailleurs de France, de Suisse et d'ailleurs. Et nous avons sur ces 2 jours de très belles participations, de beaux panels à suivre, sur lesquels il y a des animateurs de grande qualité. Et nous avons, je suis sûr que nous avons une très belle conférence en perspective. Le travail fait avec SOAS, la relation avec SOAS et CIMAC date de quelques années déjà. Nous avions déjà le plaisir d'avoir Dr Onyema comme participante et speaker dans les Casablanca Arbitration Days. D'ailleurs, cette année, les Casablanca Arbitration Days ne se tiendront pas. Décision prise par le comité d'organisation, même pas en webinaire. C'était d'ailleurs la semaine de l'arbitrage à Casablanca, cette semaine de 22 novembre, parce que nous avions eu normalement le 23 et le 24 la conférence SOAS et le 25-26 la conférence les Casablanca Arbitration Days. Cette année, le comité d'organisation a décidé de la reporter à l'année prochaine, espérant que l'année prochaine, on pourra la voir physiquement à Casablanca. Cela dit, comme je disais, le partenariat avec SOAS est très intéressant. SOAS fait un travail formidable pour la promotion de l'arbitrage, déjà sur notre continent. L'université SOAS avec Dr Onyema et la plupart de ses étudiants que j'ai eu le plaisir d'avoir et de rencontrer quelques-uns sont des pépites en la matière, de profils très diversifiés, très compétents. Et c'est grâce à Dr Onyema. Il faut vraiment, moi je lui rends hommage de tout le travail qu'elle fait à travers SOAS, à travers les initiatives qu'elle porte sur tout le continent. Et à chaque fois, elle est disponible, elle veut aider, et notamment aider les jeunes à prendre la place qu'il leur est réservée et d'être parmi les leaders de l'arbitrage sur notre continent.
Amongst the leaders of the arbitration. There's space for everyone. We have a very rich continent in raw materials, minerals.
Différentes matières, soleil, énergie, un continent très très riche aussi par sa jeunesse, sa forte population jeune qui se développe, qui arrive sur le monde du travail, qui a de plus en plus pris les choses en main en termes d'éducation, avec les meilleurs diplômes, les meilleures universités, qu'ils soient sur le continent ou ailleurs. C'est-à-dire que nous avons la pépinière pour avoir des experts, en tout cas dans le domaine de l'arbitrage. Et l'initiative SOAS et tout ce qu'elle fait, Dr Onyema à son équipe, viennent un tout peu marquer cet engagement-là très fort de plusieurs années. Et le CIMAC ne pouvait que d'abord être le hôte de cette conférence et d'être partenaire de SOAS. Voilà, je ne veux pas très m'étaler. Le CIMAC, pour ceux qui ne le connaissent pas, en fait, c'est une jeune expérience. Il faut que je précise quelques éléments, c'est important. Certes, le Royaume du Maroc a une longue expérience dans l'arbitrage international. Le Maroc fut parmi les premiers pays qui ont reconnu la Convention de New York, qui reconnaît l'arbitrage international. Premier pays qui a ratifié la création des CRD, l'EXID, Washington, qui a appliqué les arbitrages internationaux au Maroc de manière assez intéressante, qui a une législation particulière et sur laquelle aujourd'hui, nous allons très bientôt, dans les prochaines semaines, sortir un code de la médiation et de l'arbitrage à part qui sort du code de procédure civile. Il y a une avancée par rapport à la législation en vigueur. Alors, le CIMAC, il est venu dans l'initiative faite par Casablanca Finance City, qui est le nouveau district aujourd'hui physique de Casablanca, où les opérateurs financiers marocains et étrangers sont installés dans cette zone aujourd'hui qui a pris forme, où le CIMAC siège d'ailleurs à la tour CFC, qui est une très très belle tour, et le quartier aujourd'hui connaît un essor très très intéressant pour ceux qui l'ont déjà visité. Et Inch'Allah, après la pandémie, on sera ravis de vous accueillir dans les locaux des CIMAC et de vous faire visiter cette zone qui prend un développement très, très formidable et qui est très prometteur. Alors, avec le lancement de CFC, de Casablanca Finance City en 2010, il était important de voir comment faire en sorte qu'il y ait un centre international de l'arbitrage. Certes, il y avait des centres locaux. Hein. Comme je disais, le Maroc connaît l'arbitrage depuis les années 50 du siècle dernier, avec la reconnaissance et la ratification de la Convention de New York. Mais il n'y avait pas encore de centre international avec des arbitres étrangers, des arbitres qui viennent d'horizons différents. C'est un travail qui nous a pris beaucoup de temps, j'allais dire depuis 2010 jusqu'en 2016-2017. Où nous avions la possibilité d'avoir un centre d'arbitrage et de médiation. Maintenant, on parle plus de l'arbitrage, c'est le thème de notre conférence. Le centre a été lancé réellement et juridiquement en mars 2016, sous le nom du CIMAC, Centre international de médiation et d'arbitrage de Casablanca. Et le règlement de l'arbitrage qui a été amendé est entré en vigueur le 1er janvier 2017. Ça veut dire que le centre, il est très jeune, même si le royaume connaît l'arbitrage depuis plusieurs décennies. Nous avions eu la chance d'avoir, dès le départ, de grands noms qui nous ont rejoints au niveau de la Cour d'arbitrage. La Cour est aujourd'hui présidée par Laurent Lévy, qui est l'un des arbitres les plus connus au niveau international, de nationalité suisse et de formation à la fois francophone et anglophone, et qui opère à la fois sur l'arbitrage institutionnel, l'arbitrage investissement, CRD, ou l'arbitrage, j'allais dire, au niveau des entreprises, que ce soit en Europe ou ailleurs. La Cour que nous avons est composée de 16 membres, dont 3 uniquement sont marocains. Et la Cour opère en 4 langues, en arabe, en anglais, en français et en espagnol. Et nous avons bien évidemment essayé de trouver des arbitres qui viennent d'horizons différents, comme le law, civil law, d'Afrique, d'Amérique, d'Asie d'ailleurs. La Cour elle est installée, comme j'ai dit, depuis 2016. Certainement, il y aura des renouvellements dans les prochaines années, parce que, comme les statuts de CIMAC l'annoncent, il y a un renouvellement à la fois de la présidence du CIMAC, mais aussi de la Cour et de ses membres. Et on espère que la prochaine fois, on aura, j'allais dire, plus, en tout cas mon souhait personnellement, que j'ai partagé avec la Cour, plus de, j'allais dire, d'Africains, déjà, plus de femmes africaines, pas nécessairement du Maroc, et permettre aussi de jeunes arbitres qui peuvent nous rejoindre, qui ont déjà une expérience établie dans le domaine. Nous avons déjà commencé à traiter les dossiers, ce qui est quelque chose d'intéressant. Les premiers dossiers sont arrivés en 2020 et nous avons traité les premiers dossiers 2020-2021. Les dossiers d'arbitrage qui concernent le secteur privé uniquement. L'autre particularité que nous avons remarqué, c'est l'arbitrage entre le public et le privé. Le secteur privé et le secteur public, des projets d'infrastructure, des projets d'énergie, où le CIMAC il est sollicité pour donner son avis et procéder à l'arbitrage. C'est quelque chose d'encourageant. Nous avons les premiers dossiers, hein. C'est juste les balbutiements du démarrage du centre, mais c'est un gage de confiance et c'est un gage de bon lancement de nos activités. L'autre chose intéressante, c'est une particularité, je pense, dans la zone. Le CIMAC a été choisi par le MCC, le Millennium Challenge Corporation, qui est basé à Washington, qui, pour la deuxième fois, a octroyé un don assez important au Maroc. Le premier compact était de 500 millions de dollars, le deuxième de 400 millions de dollars, et le CIMAC a été choisi par à la fois les équipes de Washington et les équipes basées à Rabat, qui est notre capitale, comme le centre d'arbitrage. Et nous avons la chance d'avoir les premiers dossiers qui arrivent de ce programme assez ambitieux et assez important pour à la fois le Maroc et la région. C'est un signe aussi de confiance et nous remercions d'ailleurs nos partenaires. Et c'est que le commencement, comme vous savez, notamment.
But just the beginning. as you very know, we need to show that we are transparent and we can...
pour montrer notre compétence, notre expertise. C'est un bon signal, mais on espère aller de l'avant. Je ne veux pas très m'étaler au-delà. Je passerai la parole à Emilia, ma chère camarade, confrère. Et je vous souhaite tous, quel que soit votre horizon, une très très belle conférence, de beaux partages, de beaux moments de partage, qu'on échange entre nous. Et on espère, et Dr Emilia m'a promis que si les conditions le permettent, peut-être qu'on fera pas la conférence SOAS dans ce format en présentiel, mais on essaiera de faire une session, peut-être de formation ou autre, à Casablanca, en marge d'un autre événement que fait le CIMAC. Merci infiniment, très bonne journée, très belle conférence.
Thank you very, very much, Hisham. Thank you for your very warm welcome. So for those of us speaking English, we started...
Pour ces mots de bienvenue, on a commencé à entendre l'interprétation il y a peu de temps, mais je suis sûr que nous allons recevoir donc la présentation qui vient d'être faite par Hisham. Et nous la...
What Hisham was talking about, especially the introduction of to CIMAC and the work that CIMAC is beginning to do. I had some good figures, some good millions of dollars. So there is work, and it's important that we send Hisham emails to let him know that, you know, we're here. And if that opportunity comes, I'm sure that Hisham would call upon us. So thank you very much, Hisham. It is my singular honor to now give my own welcome address to say welcome to you all. And I have written a few pages, which I will try and read out before our keynote speaker comes on board. So welcome again to our 7th SOAS Arbitration in Africa conference, which is holding virtually. And it's been hosted by CIMAC, as we have all heard. At our Douala conference in March 2020, we promised you all a wonderful time in the beautiful city of Casablanca. This was at the beginning of what we now know as the COVID-19 pandemic. For those of us who were in Douala, that trip was our last trip outside of our countries in 2020. It is the same pandemic that has made it impracticable for us to meet in person, as we promised you, in Casablanca. We are instead meeting virtually, but we still will keep our promise that you would have an informative and substantive 2 days of deliberations, discussions, and thought-provoking ideas. Our speakers are all ready to be unleashed on you. So I want to remind us what the SOAS Arbitration in Africa Conference series is all about, how we started and how we got to where we are. It was born out of a 4-year research project titled Creating a Sustainable Culture of Arbitration as a Mechanism for Commercial Dispute Resolution in Africa. And the research project was between 2015 and 2018. The methodology that we adopted for that particular research project was to use various conferences to enable us gather people together who work in this area, particularly in Africa, and to enable us understand what is actually going on as it relates to international arbitration in Africa, and which Africans are actually engaged in doing that work. And the goal of the research project was on the transformation and enhancement of the use of arbitration as a dispute resolution of choice within the African continent. We read a lot of things and we hear, oh, arbitration is the default dispute resolution mechanism in cross-border commercial transactions. but we were not sure that that was actually that was the position on the continent. And we wanted to find out. And so out of that research project, we've published 2 edited book collections, both published by Kluwer. The first one in 2016 examined the role of arbitral institutions. And the second one in 2018 looked at the role of national courts in arbitration. The other thing is that at the end of each conference, we produced all the papers and slides that were used. So we have the 4 conference papers on our SOAS website. The conference took us to different parts of the continent, and we've sort of circled back to them. So the first one, which was in 2015.
Première donc a eu lieu en 2015 et nous avons donc interrogé le rôle
of arbitration in Africa was co-hosted by the Africa Union Secretariat, the Commission, the Secretariat in Addis Ababa. And you can see once our keynote speaker starts, you would understand why I said we've circled back to the AU. And that was in 2015. In 2016, we went to Lagos. So we moved from the Horn of Africa, if you like, to West Africa. And then in 2017, we came up north to Cairo. And today we're back up north. We're in Casablanca, virtually. And we then went to East Africa. In 2018, we were in Kigali. That was the end of the research project. But at our conference in Kigali, colleagues, our French-speaking colleagues especially, were not very happy that we hadn't been to any French-speaking country. And our colleagues from the Sudan strongly protested and said that the conferences were really, really helpful and useful. And so as a community, we agreed that we will repurpose the conference series and we will carry on having the annual conference series, but it would have a different purpose. And so in 2019, our colleagues in Sudan were meant to host us. So we're meant to go to Khartoum in 2019. And unfortunately, they had serious civil unrest a few weeks before the conference was to take place. And our colleagues in Arusha were kind enough to welcome us. And so we had almost a joint event between Khartoum and Arusha in 2019, but we were in Arusha, where we all know that in Sudan, there's been another round of upheavals. Our keynote speaker is engaged in some work in Sudan as well. And we wish our colleagues in Sudan well. We have them in our hearts, and we continue to hope that there will be stability in the country to enable the country to grow. Last year, 2020, as I already said, we had our very first major conference that was primarily in French. And for all of us who have refused to learn how to speak French, we had to make do with translation and interpretation, which was very good. And so we were in Douala in 2020. Now, this conference series, it had some major impacts, and I just want to mention a couple of outflows from the conference series. It is the conference series having with our track record, the following people who have been dedicated, and that's all of you attending the conference and those who registered and hopefully would attend later. That gave birth to what we had termed the SOAS Arbitration in Africa surveys. The purpose of the surveys is basically to try to gather original data, empirical data, data that we can rely on what is happening as it relates to arbitration. And we're beginning to expand it a little bit to all forms of alternative dispute resolution apart from litigation before national courts, what's happening on the continent. And what that is doing for us is that the information we gather, the reports we put out there, is contributing to international understanding and discourse as it relates to international arbitration, which means that your voices as Africans are being heard internationally, and we are helping to shape the development of arbitration globally, arbitration principles globally. So our first conference was, our first survey was in 2018. The second one was in 2020. So we have our third survey that will come out in 2022. Early in 2022, we'll send out questionnaires to you all. And so we rely on you completing those questionnaires to enable us produce our reports. So when we call upon you, we're very, we hope you will continue to respond. The next major contribution from the research project is what three of us, myself, Kamal Shah, and Stuart Dodson of Simmons & Simmons. Kamal Shah is with Stevenson Harwood. The three of us got together and we put together the African Promise. The African Promise effectively is, it's online, and we're going to give you the link so that those of you who haven't signed up can consider if it's something you want to sign up to. But the purpose of the African Promise is similar to the ERA pledge, the Equal Representation in Arbitration pledge. And we got their, they allowed us, they permitted us to use a form of their own wording. And the idea is for those who appoint arbitrators, when the opportunity arises for them to appoint arbitrators, that they would consider appointing African arbitrators in appropriate cases. Now, we've got some feedback regarding some of the wording we used. So the next stage for us is to revisit the text, and we need to also understand how we can capture the impact. Is the African Promise, is it delivering? Is it getting us to where we want to be? And to enable us understand that, we do need to monitor the signing and the use to which the promise is put. The other thing that we then did, and this came out of our 2018 conference, was we had quite a number of young practitioners. Hisham already alluded to this in his opening remarks. And the question for us is, how do we ensure sustainability, continuity, that, we're human beings, so we move on. And how do we ensure that that pipeline continues to be fed so that we do have better and more qualitative African arbitration practitioners? And one of the things we felt we could do was to begin to deal with and work with law students, or those students who are interested in alternative dispute resolution. For those of you who have been to the Vienna Moot, one obvious gap is the very limited numbers of African teams from African universities that participate in the Moot. And so a group of us, mainly academics, got together and we formed a charity called the Arbitration Fund for African Students. And we have a website. I'm going to put that in the chat later on as well for you to just sort of check out and see. And one of the things we've done this past year is we've had what we call the AFAS conversation series, where we invite a known arbitration practitioner from the continent or outside of the continent that works in the continent or on African matters. And we just have a conversation. They tell us how they got into arbitration, and again, some practical tips and learning for us. The other thing we have is that on the website, we've produced some content, some basic information on arbitration in form of 2-minute maximum videos. And it's fun. They're amateurish videos, which even makes it much more fun to watch and listen to. And we also fund applicants who want to go to the moods and conferences and things like that. AFAS is funding some of the students attending this conference. This year, we started working with young members groups because we figured that the young members groups are actually closer to us and the young member groups are closer to the students. And so that we have a clear trajectory of the work we're doing. So we're beginning to do more with young members groups, and we hope to continue doing that. So that is what we've been working on and what we continue to work on, which means your attendance at the conference, at our various conferences, is not, it's not a waste of your time. It's not selfish. It's not just you coming to understand what's going on, making some good contacts and going away. No, what you're doing is it's encouraging us, it's helping us know who is actually engaged in arbitration and can support the next generation of arbitration practitioners. That takes me to 2021. But I had promised I was going to tell you the new iteration of our conference series. So starting from 2019, what we now do is when we are invited, we're invited by colleagues in a lesser known jurisdiction for arbitration. And we then go in, we support them, we work with the local team, usually the arbitral center, just like we're doing with CIMAC, to organize the conference. And we work with them, and what the capacity we bring is we can source speakers along with their own speakers as well. But they do the organizing, and I'll come to thank all those who have supported us with this particular conference. So the theme of this conference is navigating the interest of African states in international arbitration and mediation. You will notice that we've now added the word mediation. We have a group within that came out of this conference series that focuses on mediation. And it's co-led by one of my colleagues, one of our professors, research professors, who is actually in Loyola, but also is with us here at SOAS, Professor Hiro Aragaki. And so that's another group that you may want to, if you're particularly interested in mediation, they're doing some serious work, and we're going to hear them tomorrow at one of our panels. So that's the theme of this conference. And why did we think that the interest of African states, we can dedicate 2 days to just understanding and looking at that? There's the backlash. We all have heard about the backlash against investor-state arbitration. That tension between investors, the interest of the investor and the interest of the state. And the state is not yes, it's inanimate, but ultimately it represents human beings. You know, one of the things I say for me is that when you have, I think when you have an arbitration award for XYZ hundred of million or billions against, let's just say, an African state, remember that it is the widow in some village who has no other means, who is not getting effective state support, that we're actually taking that money away from her and her children's future and giving to some foreign investor. But at the same time, the question is, how do we balance out those interests? Because as we know, the investor is not a charity, the investor is a business, and the investor maybe has committed funds and money and things like that, they shouldn't be left out of pocket. But the state as well should not be so constrained that the state cannot effectively provide and function the way it should function for the benefit of its citizens. So the question we're engaging in is, where do we draw that line? How do we balance out those interests? Those discussions are happening at UNCITRAL Working Group 3. The other thing that has really taken center stage is the Singapore Convention on mediation, on the settlement of mediated, on the enforcement of mediated settlements. And that's what our mediation team would look at. The last thing that has really had a major impact is the Africa Continental Free Trade Area Agreement and its protocols, and how that would impact on the development of African states. So we have 5 panels. They will look at all of these issues. They would engage with them. Some people have some very, very far-reaching ideas, but they have come prepared to speak. They want you to listen to them, but they also want you to engage with them. So I'm fully aware that all the chairs, all the moderators have ensured that they saved adequate time to hear you, for you to engage with them, for you to ask questions and make comments. So our first panel, which will start in another 2 hours or so, will discuss the economic, socio-legal, and developmental interests of African states to help us, to provide us with an understanding of the needs of African states and governments from the international community. Our second panel will pick up from there and then look at international investment agreements and the development of African states. So today is a bit heavy going because we need to lay very solid foundation and context. So it might be a little bit heavy and technical, but it's important that we also sort of listen and engage with that to give us some good understanding. We have Stephanie Mbono, who's going to come and talk about greener arbitrations. We all watched and some people attended the Glasgow COP26. I'm not sure I know what COP is, but anyway, COP26. I know it's the 26th meeting and that was recently concluded. And so what greener arbitration, what they do is to try to give us understanding and help us as arbitration practitioners to reduce our carbon footprint and what it is we can do. And Stephanie will deal with that. We still know that with the women, engagement of women in international arbitration, that we're gaining some traction, but I'm also beginning to query some of that traction, whether we're moving from male pale still to female pale, maybe not necessarily still, but that's not the vision. And so we would have Amani Khalifa, who would come and speak to us a little bit on where the Africa subcommittee of the governing body of ERA Pledge, where they are at and how we can support them better. So that would be the end of today. Tomorrow, we have 3 panels. And tomorrow we then move into dispute resolution proper. So our third panel, which will be the first panel tomorrow, would begin to engage with African states and international investment arbitration. As a matter of fact, there's one of the predominantly Francophone African countries that a couple of it, that 20-something billion US dollars claim was filed against them a couple of weeks back out of the mining sector. And that is huge. And this is a country that, you know, it's not, it's not very well developed. Let's leave it at that. Our fourth panel would then engage with mediation, with how African states can promote the use of mediation in both domestic and cross-border disputes. Remember what I said, that mediation is becoming really important. And that panel is usually organized by our mediation, if you like, subcommittee. That's that mediation group I mentioned to you, which I think it's important for those of you particularly interested in mediation to join. Our last panel, which is the panel I would also speak on, and that panel, our moderator is going to moderate in French, and some of us will speak in English and some will speak in French. So it's going to be an exciting panel. But what we would be looking at the last panel is dispute avoidance. How can we get African states and parties to avoid getting involved in international disputes in the first place? Most times when we talk about, oh, the state won, in the sense that the investor did not get any money, pecuniary damages, we forget that there's a cost element to the time that has been spent in trying to resolve the dispute or to go through arbitration. The cost, the legal cost to the state, the cost of people from the state flying all over the world for the dispute resolution mechanism and the process. All of that has a cost element to it. And so if the states can avoid these disputes in the first instance, that might actually be very helpful. That's our last panel. And that is what we're going to discuss over the next 2 days. And we very much hope that you would find all of this exciting. As you can see, I'm very excited about the next 2 days. We're going to get you to do some polls as well for each of the panels. We will pull up a poll to gauge and understand what your views of the discussions are at each of the panels. The conference is being recorded, and so please, we expect that we have your consent to record the conference. We have the consent of our speakers and our keynote speaker. There is a chat function, I've been told to remind you. Some of you are already active on the chat. I think that's really, really exciting. It's one of the very, very interesting things to watch and to read and contribute to the discussions going on in the chat. I've been asked to also remind you that lower down, there is a Q&A button. Feel free to ask your question in French, English, Arabic, that's fine. Even Swahili, that's fine. We have people that can help us understand what the question is, and then they will try to answer. We have papers from the conference, but we're going to publish either in a journal or as a book. So some of the slides we would use, you would have access to those. The papers, you would have access to those as well. So that's it really. It's for me to say a huge thank you. Lots of thank yous to those who are our partners. If you go back to the registration webpage, further down, you'll see a list of those who have continued to support us with advertising, telling their members about the conference. Our sponsors, we have received tremendous support from Marie-Andre Ngwe, from Nagla's law firm, Nasser Law in Cairo, from SOAS, my own university where I am, and of course from CIMAC. It is their conference, and they've really, really been very helpful. But it's important to also mention some names. And so I want to thank Iman, who from SOAS has just been amazing. She graduated a couple of years back from SOAS, and her law firm is down the road from me, but she's amazing. She's just taken this on. Thank you very much. And then, of course, on CIMAC side, we have Yasmin, we have Zuhair. You've already heard Zuhair speak. We have Otman. They've just been on top of this and tried to sort all our difficulties out. And of course, a huge thank you to Hisham for accepting our invitation for CIMAC to host this conference. There's a young man called Madi, and it's important for me to say he's a young man because he's our social media guru. So he's done all the tweeting and all the, all the others. And so it's a huge thank you to Madi. He's going to continue to tweet and do the things that some of us have no clue how it's done. So thank you, Madi, very, very much. There are colleagues of mine from SOAS who one person is speaking and the other is chairing a panel. So Hussein Hari is speaking tomorrow, and Michael Bartlett is going to chair a panel tomorrow. We're all at SOAS and myself. Okay, so that brings me to the end of my welcome. Enjoy the conference. And so I think we can take about 5 minutes just so that we can get up, sit down, and then we come back and we introduce our keynote speaker who would start speaking in 9 minutes. Back to you, Zuhair. Thank you. Okay. I think we can start. I can see our keynote speaker. So I'd like to introduce our keynote speaker. Our keynote speaker is Ambassador Dr. Namira Negam. And she is the legal counsel and director of the Department of Legal Affairs at the Africa Union. She's held this position since 2017. Before 2017, she was the ambassador of Egypt to Rwanda between 2014 and 2017. She has also headed the anti-corruption unit at the Ministry of Foreign Affairs of Egypt between 2013 and 14. She was the legal advisor and counter-terrorism expert of the Egyptian mission to the United Nations in New York. This was a position she held between 2006 and 2010. She served as the legal and political officer in the Embassy of Egypt to the Netherlands. So you can see she's been all over the place. My excitement at just listening to her speak, you would catch that bug once she starts speaking. And she was in the Netherlands between 1999 and 2003. She's occupied various positions. She was the vice president of the Assembly of States Parties of the United Nations Convention on the Law of the Sea. She was the vice chairperson of the Ad Hoc Committee on International Terrorism, the 6th Committee. And she was the coordinator of the Africa Group in New York for legal matters. She is currently the lead for the AU team for establishing the hybrid court for South Sudan. It is my honor to welcome my own sister. I've claimed her as my, as an African woman, I've already claimed her as my sister. So Ambassador, the floor is yours. Thank you very much for joining us.
Thank you very much, Professor Emilia. It's my pleasure to be with you today, and thanks to SOAS and CIMAC for inviting me at this conference. Ladies and gentlemen, joining us from around the world, good day. The African Continental Free Trade Area needs no introduction anymore. It's arguably the African Union's biggest project since the launch of Agenda 2063 in January 2013, which constitutes the blueprint for sustainable development and economic growth of our continent. So today, my address will focus on arbitration as a means to settle disputes in the wake of the AfCFTA. I know I've been asked to speak for 50 minutes. I will probably speak shorter, and I will be happy to entertain any questions. It is true that the AfCFTA was born out of the mutual desire for economic growth and fight socioeconomic ailments, including the illegal migration that leads to the loss of life of many of our youth. This noble objective may be good enough if we are in utopia. Why? Simply because states have the differences. States are inherently selfish when it comes to their interests, and states are motivated by what is in it for them. So luckily, whether for the utopian goal or for interests, AU states managed to have a brilliant treaty adopted. Yet differences are bound to happen, and disputes between states on the interpretation and application of the agreement's provisions will occur. As a consequence, it's not only natural, but rather essential that international trade agreements incorporate provisions that provide for effective dispute settlement mechanisms. AfCFTA is no different. Article 20 of the agreement establishes a mechanism to settle disputes arising between states parties only. The mechanism is to be administered in accordance with the Protocol on Rules and Procedures on the Settlement of Disputes, which is part and parcel of the agreement. This is a similar model to the World Trade Organization dispute settlement mechanism, which consists of a dispute settlement body, panels, and an appellate body. So what about arbitration? Well, pursuant to the AfCFTA protocol on dispute settlement, recourse to arbitration is a matter of choice to be made jointly by the parties to a dispute. Article 6.6 states that where the parties to a dispute consider it expedient to have recourse to arbitration as the first dispute settlement avenue, the parties to a dispute may proceed with arbitration as provided for in Article 27 of this protocol. Based on this provision, we can safely say, first, within the AfCFTA process, these parties can choose to recourse to arbitration as a means to settle their disputes, but they are in no way under any obligation to do so because we have another mechanism. Second, the scope of access to arbitration is limited to the first instance only. This means that in case of unsuccessful consultations, states mutually can decide to refer their dispute to the dispute settlement body created under Article 5.1 of the protocol. Hence, the option of arbitration is taken off the table. However, the DSB, which is the dispute settlement body, must still be notified of the decision to go to arbitration. So here the upper hand will always going to be for the DSB. Third, all parties to the dispute must agree to explore the option of arbitration. So there is no room for a unilateral referral to arbitration. In a way, this requirement protects smaller and poorer states from being forced to submit to the choices of the bigger and richer states. As for the specific requirements to resort to arbitration, they are elaborated in Article 27 of the Dispute Settlement Protocol, where the parties to the dispute have to mutually agree on the procedures to be followed in the arbitration proceedings. Presumably, this would include the applicable rules such as UNCITRAL, ICC, etc., as the provision of paragraph 1 of Article 27 is silent on such options. The parties are barred from simultaneously referring the same matter to the DSB. Once they agree to refer a dispute to arbitration, obviously, they have to wait until the outcome. This is to avoid a duplication of efforts. Moreover, they are obligated to notify the DSB of the decision to resort to arbitration and must jointly agree to a joinder of third parties to their proceedings. They should abide by the arbitration award and they should notify the DSB of such award for enforcement. And finally, in the event of the refusal of one of the parties to cooperate, the complaining party shall refer the matter to the DSB for determination. Also, this provision states that arbitration awards shall be enforced in accordance with the provisions of Article 24 and 25 of this protocol, mutatis mutandis. Now, this is where it becomes a little more complex. But before I move to address the enforcement mechanism, allow me to comment quickly on the requirements I have just mentioned. If we analyze thoroughly Article 27, it's easy to discover that emphasis was given to show that arbitration under the AfCFTA is a first instance mechanism, as it requires the parties that chose arbitration to conclude it before resorting to the DSB, should their arbitration fail. What is even more interesting about this provision is that while it requires the parties to abide by the arbitration award, it does not necessarily mean that such award is final. That is to say that the provision does not expressly bar any of the parties from having further recourse to another dispute settlement mechanism, in this case, the DSB. Now, moving back to Article 24, which is about surveillance of implementation of recommendations and rulings, and Article 25 on compensation and suspension of the concessions or any other obligations under the AfCFTA. Let's start with Article 24. In paragraph 1, it stipulates that states parties shall promptly comply with recommendations and rulings of the DSB. This includes arbitration awards, which, as I mentioned earlier, are enforced by the DSB. In this regard, this article also makes provisions for circumstances where states may find it impractical to promptly comply, in which case the concerned state may be granted an extension of time to do so. The time extension can be granted on 3 grounds as follows. A period of time proposed by the concerned state party subject to DSB approval, a period of time mutually agreed upon by the parties to the dispute, or if the previous 2 fail, a period of time determined through binding arbitration within 90 days after the date of adoption of the recommendations and rulings. So first, the priority is given to the mutually agreed time or to a proposed time as approved by the DSB. If all that fails, then we have to go again to arbitration here. In this situation, recourse to arbitration is very different from the one referred to under Article 27, as it is used not to settle a dispute arising out of the interpretation or application of the AfCFTA, rather as an after-the-fact mechanism to make a determination on the time to be granted to the state against which a ruling or recommendation was already made or an arbitration award already issued. Now, moving to Article 25 on compensation and the suspension of concessions or other obligations, we will find that the measures stated under this provision are meant to be temporary in nature. They are only made available to the aggrieved party in the event that the recommendations and rulings of the DSB are not implemented within a reasonable period of time. Of course, we know that if the matter gets to this point of considering the suspension of concessions or other obligations, then it must be very serious, which is why there is a strict application of the principles and procedures listed in Article 25.5 before an aggrieved state can be granted authorization to suspend concessions or obligations under the AfCFTA. In this circumstance, recourse to arbitration is proposed where the defaulting state objects to the granting of authorization to the aggrieved state to suspend concessions or obligations. The process for such arbitration is set out in Article 25, paragraphs 8 and 9 of the Dispute Settlement Protocol. And like the one proposed under Article 24, it's very different from arbitration as a means to settle disputes under the AfCFTA. In Article 27, the arbitration is used as a first instance adjudication process, while in the latter case of Article 25, the parties to a dispute shall accept the arbitrator's decision as final, and the parties concerned shall not seek a second arbitration. Yet, although Article 24 didn't expressly mention that the arbitration as a means to settle their disputes regarding the duration of the extension or in relation to the full implementation of the award, it has stated in paragraph 3C that the arbitration in this case is binding. So here we have different phases to the arbitration. The first arbitration, as mentioned under Article 27, is a first instance arbitration, while Article 25 and 24 said that one, in Article 25, expressly mentioned that the decision of the arbitrators is final. And in 24, it mentioned binding arbitration, which more or less lead to the finality of the adjudication process in the matter. The common factor that can easily be identified in both Articles 24 and 25 is the attempt of the negotiators to ensure that in case of disputes arising in relation to the execution of the arbitration award, their preference is to settle such disputes through the original panel. Yet, in case of difficulties, they created different means to appoint arbitrators or settle the disputes. Here, we can find that the Secretariat and the DSB play bigger roles than simple surveillance in the form of monitoring the implementation of awards, because they made like several steps and to make sure there is no lacunae if the parties fail to resort to the original panel that issued the award for the differences coming after the issuance of the award for implementation. So they put different scenarios to make sure that the award will be respected and the decisions will not be prolonged. Based on all this, it's fair to say that arbitration is an important means to settle disputes in the wake of the AfCFTA. However, whether disputing state parties will choose to go down that route is a determination to be made by the states themselves on the merit of each situation. Certainly, the concerned state parties will each weigh their options based on a number of factors, including time and cost, as well as a willingness to even agree with the other party to go to arbitration. So what does that mean for academics, arbitration centers, arbitrators, and lawyers in Africa? I would say we have a new instrument to play with. I personally believe that the AfCFTA will assist us in flourishing. African arbitration that may be the outcome of transactions under the agreement will hopefully be managed and adjudicated within the continent. Back to our slogan of African solutions for African problems. If my wishful thinking is in place, that means all of us in the international legal field, especially those who are involved in arbitration matters, will need to study the ins and outs of the AfCFTA, like states' obligations versus traders, etc. In this context, we will need capacity building and education to ensure the proper understanding of this new text to enable the appropriate implementation and for advising our clients from both governments and incorporations to the best means to settle the disputes arising from such implementation. This is something we have to fight for, especially African arbitration centers, who should showcase of their facilities and list of competent arbitrators to be used by any parties who would like to resort to arbitration as means to settle the disputes. I honestly don't see the logic of why we would leave this opportunity slip from our hands. It's a golden one that we should grab and hold on to in order to ensure that the entire process relating to the AfCFTA remains within our continent. It's important to stress before I conclude on the issue of education and capacity building. The AfCFTA is a new instrument. It's young. So we need more commentary from the side of academics. We need more literature to depend on. Also, we need a lot of capacity building in relation to the arbitration centers, because simply we have enough arbitration centers in Africa. Some of them are very prominent, some of them are yet to stand tall and showcase of their abilities. So we need the capacity building for those who are running the centers themselves, to how to market themselves within the governments and the arbitrators, while also we need capacity building for the lawyers and governmental officials who will be involved in the cases, be it agents for governments, lawyers for governments, or arbitrators. We need to educate people of the CFTA rules in order to enable us to succeed in having a proper arbitration for any disputes arising from the implementation of the CFTA. It's a fast mechanism, it's easy, but it's costly. So this is actually, I think, because this will be a vast opportunity where even the centers can cooperate and can compete, which will, I hope, bring the prices down for Africans when they go for education under arbitration. Thank you so much for your kind attention, and I look forward to hearing from you and your comments and feedback. Thank you very much, Professor.
Thank you so very much, Ambassador. I'm sure that people are still sort of thinking about what you said. Thank you for that call to the various groupings and sectors within our industry, and what we need, reminding us of what we need to do to take advantage of the opportunity that the AfCFTA presents to us. You ended on costs. And I have experience of arbitrating on the continent and outside of the continent. And one of the things for speaking as an adjudicator is that I don't earn enough. I actually earn more money when I sit as arbitrator outside of the continent than when I sit as arbitrator in the continent. And one of the concerns that I have is, how would our African centers attract qualitative arbitrators if they're not able to pay them well comparatively? And yes, we understand why they may want to charge a lesser fee for, from parties. But how can they then, how would they be able to attract and retain talented arbitrators if they're not paying well, comparatively?
Thank you very much for that question. Actually, I do believe that that's why I ended up with being in cooperation and also at the same time in competition. Bringing the price down is to the benefit of the parties. And due to the fact that we have now a mechanism in place, which is the DSB, which is basically the other choice for dispute settlement, the parties will choose between both. Mm-hmm. And the parties, be it governments or the traders themselves, they will definitely go for the cheapest option if it is efficient and if it will be just enough for them. So this is something I think also for, as you said, the talented arbitrators or lawyers to consider. Why? Because then here we are talking about more competition. You know very well, more competition means prices go lower. Instead of having the dispute going to the ICC in France and both parties are Africans, then it will go into one center in Africa. Now, at a certain point, if we succeed in our endeavor and make sure that the arbitration centers in Africa remain as strong as they are and go stronger, the international lawyers, including African lawyers in the diaspora, will have to lower their fees to come to this arbitration. Why? Because it's a market strategy. Now we're talking not about lawyers, we're talking about just the market and prices. We are talking about the market strategy. Now, I am a lawyer, I want to be more known in my field, and the more cases I win, the more cases I will get. So now it will be of the quantity as well will count. At the same time, when we are starting to do proper capacity building and proper education, you will create a new generation who might not be abroad, because the comparison always comes when you are working in a rich country and you get arbitration as a lawyer or as an arbitrator to sit in one of the big institutions. So your fees are very high, it's by the hour. But if we are talking about a generation who are raised in Africa, who are groomed to be able to meet the standards of the DSB or the arbitration, and they get the trust of their governments, the fees will be lower ipso facto, because the living standards in the countries they are coming from is different from the living standards from the Western Hemisphere. So that will lower the prices of arbitration, and that will be to the benefit of the continent on one side, and at the same time to the benefit of arbitration in the continent. Because again, this is under CFTA is a choice. We are still having the DSB, because under other trade agreements, it might be very clear, strict, that you have to go to arbitration. So whatever cost and whatever the seat is, you will have to go for.
Il faudra aller de l'avant. Ça, c'est un risque que l'on prend lorsque l'on signe donc un accord avec une clause d'arbitrage. Mais au niveau de la ZCAF, c'est un choix. Si...
For adjudicators, if they find going to the DSB is cheaper than going for arbitration, then the lawyers and arbitrators will lose, as simple as that. So they will end up trying to lower their fees to gain more clients. This is how I see it.
Okay, I like that market analysis. The second question is on, you talked about collaboration by arbitral centers on the continent, which I'm very much persuaded by. But one of two things. One is that from the survey we did last year, what we found is that, you know, there's the typical very busy African arbitral centers, and there are few of them. But the good thing is that they're spread across the continent. And I had written to suggest that for purposes of the AfCFTA and the dispute resolution, the dispute settlement mechanism, on the one hand, and for the private dispute resolutions, cross-border disputes that would arise between the private parties, that it might be necessary for us to consider having some, you know, breaking up the continent into regions and having clear arbitral centers that we can call upon and that are actively supported by the African Union, so that they are the ones that would administer those disputes if they arise. And you had talked about centers publishing their list, or at least making their list of arbitrators available, easily available. So I was just wondering, what do you think? Do you think that having identified arbitral centers who can help with managing these disputes, but that those centers would need to be actively promoted by the African Union, whether you think that would be...
L'Union africaine, est-ce que vous ne pensez pas que ce serait une bonne...
Well, the point is, like, let me start by why I'm saying it's good for them to cooperate. The cooperation starts from showing case that the African centers are able to run the arbitration. Because I think, in my personal point of view, that our states do not have enough confidence in our centers because they are of so many reasons. So now the first issue is to showcase that no, we are as good as the international centers and we can run your arbitration process honestly and fairly. So this is one aspect that I'm saying the cooperation has to start. Maybe we should have an association or something like, you know, like the bar for the centers themselves. So from that perspective, the centers will showcase how good they are, and their portfolios will not be like spread around online everywhere. No, it will be compiled together, and every region would know who to go to in its region. That is on one side. On the other, when it comes to the involvement of the African Union in that process, because anyways, African centers or any arbitration centers, they are independent from the governments and from the IGOs. So it's not like something that we can impose on them. But when it comes to our role, in order to make a list of the good arbitration centers regionally, this has to be negotiated via the member states. Because then, as a commission, or even as the secretariat of the CFTA, we will be crossing the line, because we will be the ones doing the evaluation of the arbitration centers. And this should not be the case, because even the CFTA left it open to choose which arbitration center. So now, if I come and say, no, CIMAC, or the Nigerian center, or the Egyptian center, or the like the Cairo center, or the Rwanda center, I will say these are the best ones. On what basis I decided that these are the best ones? Now I will be attacked from our member states on what basis I decided this center is better than that one. So I think if we want to go through that path, then it has to be put on the agenda of the negotiators in order to discuss a criteria for deciding that these are the ways that we will rank our centers. Usually, we hate the ranking. Anyone represented the member state will know we hate the issue of ranking. But at least we can say those arbitration centers are bigger than others. The other issue, which I would see of value here, is to involve the regional economic communities. If I'm speaking about West Africa, because it's a big block of states, then I would resort to ECOWAS. And I will tell ECOWAS, can you please study the best centers you have in the region? Because also ECOWAS has Anglophones and Francophones. So you will have centers that are very good English speaking and others are very good French speaking. Then by that, I can have a group of states together in one arbitration center regionally that they trust. Because also do not forget that we can have like, you will be shocked of the number of arbitration centers in Africa. It's above 70. Because we try to accumulate and compile this information before in my office. So we realized we have above 70 centers in Africa, which some of them we've never heard of. You as an arbitrator or a lawyer, you might not have heard of before. So now, either we support them or we have to make them join hands together in order to form a bigger center for them. Because it's a costly process even to have an arbitration center up and running. And to keep the facilities up and running without enough cases is obsolete, because it's just a burden on those who had found that center. So now, in order to make sure it keeps going and goes better, then we can suggest that for every group of countries, they can have trust that they will send their cases for, without jeopardizing the choice that someone from East Africa will go to the West to have their arbitration there. This is a very important factor on the CFTA, because although we are talking about here regional centers, this is a continental effort. So we are trying here to bring the entire continent together, because before the CFTA, we already have the SADC free zone, we have ECOWAS, we have COMESA, we have East African Community, we have many in our regions. But now, because we want the continental level, we are going to propose a solution which will be easier for regions, because the centers will be closer to the countries, closer to the lawyers and arbitrators from the country. So it will be cheaper for them, definitely. But that does not jeopardize their right to go to arbitrate in another region. This is something like one of the formulas I think that we can work with.
Great. I think that I completely agree. And I suppose you already made that call on academics like myself to do some more publications, to do some more research. And I think, speaking for the African academic community, I think we'll be very happy to do more research, to do more publications. It's just that we need to be funded to do some of this. And it would be very interesting if the African Union, or as you have suggested, the RECs, would be willing to fund some of these projects, or even the Africa Development Bank through the Africa Legal Support Facility will be willing to fund some of these research projects. Thank you very, very much. I'm just wondering if anybody wants to say, we still have our ambassador for another 10 minutes. Does anybody want to raise their hands, and or we can, okay. So I have one for you in the chat. It's actually 1 times 4. Okay, it says, good morning, Ambassador. Thank you so much for your address. My question relates to investor-state dispute settlement. The first one is, will the AfCFTA investment protocol, when finalized, provide for an ISDS mechanism? Why or why not? Do you want me to take do you want to take?
I think I should take them one by one, because there are so many.
Okay, okay.
Yes. Well, I do think when it comes to the ISDS, I know it's a very complicated matter. And it's yet to be seen whether we will have a full mechanism like the DSB in the trade aspect, in the investment aspect or not. Why or why not? It will be definitely depending on member states and their existing obligations. Because now, when we create more obligations to states while they are already having cases in other fora for the investment disputes, they may prefer to resort to what they know rather than going for something that they don't know. Like, for example, again, it's not utopia, but we have ICSID. Maybe we're not happy with ICSID, but we know ICSID, we know the rules. So maybe states will say, okay, no, let's stick to that. But on the other hand, because now we are creating a full mechanism for our continent, maybe states, while negotiating, will say, no, as we did in the trade, we should do in investment, we have to have a mechanism for us. We create something for us. And for me, I would adjudicate for that. If we're talking about African investments in African countries, why would we go abroad? So it makes sense that we stay within the continent. But again, it is yet to be seen when all the negotiations are finalized. I think as long as everything is still under negotiation, so all the options are open. And as we always say in the UN, nothing is agreed until everything is agreed to. So as long as the text is still open and member states are still discussing it, we don't know what we'll end up with as the final outcome.
Perfect. So the second one is, given the many controversies surrounding ISDS generally, will the drafts of the investment protocol be made available for public review and comments? I think we're really concerned that it's not public. So we're wondering whether the draft at least is made public, and that will give those of us who are academics and researchers in this area opportunities to also make comments.
Well, as you know, my history is full of negotiations. Drafts are never public. And it goes in the hands of academics when the governments want their advice in the negotiation process. So it will go public when everything is already agreed to. This is a sensitive issue for member states when they are negotiating texts, because all what we call industry, NGOs, academics, all those outside of the meeting room that is closed on governments will form sort of pressure groups on the governments. So governments are not comfortable with that. Thank God this is trade and not human rights, it's worse. But simply, why it's kept, it's not a secret, but the drafts are meant to be discussed in meeting rooms, not to be published online to listen to comments of others. At the end, when the text is adopted, you may land on the documents of drafts as part of the travaux préparatoires of the convention. But during the negotiation process, it's not normal to make it public. It goes public from a hand to a hand, just because someone was contacted by a government to ask for advice, then the person, he or she, seeks assistance from someone else, then it spreads out. But it's not formally published. It goes from a hand to a hand informally. So that's a normal thing in the negotiation process. And it's not normal to say, okay, let's publish the drafts. Unless the negotiators want to publish the drafts, that's something we have no power on.
So one of the ways that, because this question was asked by Professor Uche Ewelupa-Ofodile, she's in the US. And one of the concerns quite a number of African academics who do research and teach in these areas is the lack of, we're not engaged right from the word go. And one good example for it that we're currently using with the UNCITRAL Working Group 3 is that there's an academic forum attached to the Working Group 3. And the UNCITRAL can ask the Working Group to do some research, to do a paper on XYZ. But it brings, that way we as academics, we're also feeding into the work that the states and their representatives are doing at the UNCITRAL. So maybe that's something for the AU to sort of think about if the AU wants to set up a little working, an academic group that can at least study some of these things. The AU would instruct us on what to study, and we can then do that sort of work for the AU and the AfCFTA. Can I quickly move on to the third question before you answer that, before you sort of give me a response on that one? The third one is, as between traditional ISDS, the proposed investment court mechanism, and ISDS with reform elements, so I suppose the appeal process, is the AU moving in any clear direction? I think we're just sort of trying to push you a little bit so we know what is in this investment protocol. So what's the AU thinking about?
Well, it's like, let me first comment on the first comment. Because I'm involved with coordination of the African group in relation to Working Group 3. We have to make a distinction between the forum of negotiations and the advice services. UNCITRAL requested the academics from around the world to give them advice as a secretariat in preparing the reports. This is different from officially member states requesting academics to be part of the process. These are two distinct issues. So now it's up to every secretariat, if they do not have enough expertise within, to ask academics to join, or advisors to join as consultants to prepare something for them. I cannot speak for my colleague Wakamele Mena from CFTA. He's competent enough to handle that, and he probably knows what capacities he has in the secretariat, and whether in the secretariat reports they require assistance from outside or not. Again, there is the other face of the coin where member states themselves ask their academics, and they resort to academics to give them advice. This is known around the world. As far as the issue of a court, let me be clear. On the CFTA level, on the international level, when we are discussing the same when it comes to Working Group 3 in UNCITRAL rules, this is still a controversial issue between the African states. The African Union cannot take an independent decision on the matter without the agreement of its membership. We are an international governmental organization. I always have to remind this to many of the people in many conferences. We are not an independent entity that can go astray to do whatever we think is right. We are bound by decisions of our membership. Our membership is our member states. So if states until today did not yet decide what kind of mechanism they want to resort to when it comes to the disputes relating to investments, we cannot say it. I might have personally a preference. I might tell you the pros and cons of having a court, but that is Namira's. That is not even as a legal counsel. That will be my mind as a lawyer, as a legal person, professional, as an academic, because I did academia before, but I will not be able to tell you, okay, this is the right path. Because when you negotiate these things, you will always look at the pros and cons of every option. Some member states who are already diverting completely from the BITs and having different formulas for them when it comes to investments, be it FDIs or different formats of investment, they will not be apt for a court because they have already abandoned the entire formula that was presented to us by the international community. So doing this, meaning that at a certain point, we will have the split in the negotiations for those who are with and those who are against that project. I think it's fruitful to have the discussion in order to see the pros and cons. And when member states are taking a decision, it's very clear because the court might be a better solution for some smaller states where it will be cheaper, where they might have from their back minds that they are getting better justice than resorting to the current mechanisms dealing with the investment disputes. But that might not be the answer for those who decided to have an absolute total different mechanism in dealing with investors coming from outside of the continent. So if we move to the context of the continent, it is very difficult to decide right now what will the negotiators agree on. If they already have that controversy internationally, what will they decide when they are negotiating? Here, I have just to finish the sentence with something that you have to bear in mind, the difference between investor states and recipient states. Because when we are talking about Africa versus the world, we are mostly recipients. But if you're speaking about Africa versus Africa, we have investors and we have recipients. So within the investment protocol itself, this will be an absolute clash in perspective. because the countries that invest in others would prefer certain paths that might be totally different from those who are recipients. I'll stop at that.
Thank you very, very much. And that is really part of the conundrum, and that's part of the problem. It's really interesting when you hear the complaints of the recipient states when they are the ones receiving, and then when they become outward going, their position takes a complete spin around.
Absolutely.
And that's part of it. I think the last question is whether, if you can just give us an idea of where we are on the status of the protocol, the negotiations, what stage we are on, whether we would soon get a protocol or we need to wait a little bit more.
I cannot say that because my experience in negotiating the CFTA onwards, certain things go faster than we expect, others takes forever, also longer than we expect. We have, all I can tell you, there is a will to finalize all the legal framework of the CFTA and the remaining annexes and protocols ASAP. But for example, COVID derailed us because the debate in relation to having to resort to the negotiations online or not. Some countries did not want to, some countries accepted, then we ended up negotiating some instruments online. Now we are still in between because of COVID. Now, we have no idea what, like, if we're talking about the framework that is set by the heads of states, literally is let's finish everything now. But negotiators take their time, and sometimes we end up submitting to the heads of states requesting more time. So at this stage, I cannot foresee how long will it take that the settlement of disputes for the investment protocol will be finished. I don't know, but I just hope to say as soon as possible.
Thank you so very, very much. Thank you. Uche is very much appreciative of your comments. And thank you for the academic in you coming through with all the hedging and making sure that, okay, you're not going to be quoted anywhere. We're very, 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 very grateful. I am so grateful. Thank you for accepting our invitation. Thank you for setting the stage for our discussions. And I'm sure by the time you read our report, and I must note that we have a number of students on the who are attending, they would write up the summaries that you'd be very pleased. Thank you. Thank you so very much. And
thank you very much.
Thank you. So the next thing we have on our agenda is our first panel. Can we just take 10 minutes break so that some of us can drink coffee and stand and sit, stretch and do some exercise. So we will reconvene for the first panel in 10 minutes. And that panel is going to be chaired or moderated by Mrs. Aisha Abdallah, who is a partner at Anjawala and Kana. And so see you in 10 minutes.
Okay, is it trying me?
Good morning, panelists. I see Aisha, you and your team, you're all ready. So
I think we're missing Gregory.
Oh, I'm sure he's going to join. We still have like 9 minutes to start. But it's nice seeing everybody, seeing one. I hope we didn't wake you up.
I am. It's yeah, it's 4:50 a.m. in the morning for me.
Apologies.
No problem.
Perfect.
Before we start, can I just ask everyone just so that I make sure I pronounce everyone's names correctly. Professor Won, your surname, is it correct to say Professor Won Kidane, or am I mispronouncing? Won Kidane.
No, exactly. You're saying it very well. Thanks, Aisha.
Thank you. I think David Luke is easy, Nagla Nasser, Gregor Pannike. I just wanted to double check. Thank you.
Very good.
Okay, so welcome back. It is 11 o'clock in Casablanca, and we have our first panel. And our first panel will begin to unpack some of the ideas that came through from the keynote paper. Our first panel will discuss the economic, socio-legal, and developmental interests of African states. Their goal, their job is to try.
Leur objectif est de nous faire comprendre les besoins des États africains.
Community. So they've set themselves loads of questions that they want to deal with. I have this panel is being chaired or moderated, whichever one you prefer, by my colleague and my sister. I have lots of sisters and brothers, Mrs. Aisha Abdallah. I have put a link to her website. She's a partner at Anjawala and Kana in Kenya, and she leads their dispute resolution practice. All the bios for our speakers are on the website, but I'm going to hand over to Aisha, and then she would hand back to me in 2 hours' time. Aisha.
Thank you so much, my sister, Professor Emilia. It's afternoon here in Nairobi. Good afternoon to everyone. I would please request my fellow panelists to turn their videos on. And I'm joined today by a very distinguished panel. Their CVs are on the website, but just briefly, I would like to start with Professor David Luke. Professor Luke has extensive experience in trade and was until recently the coordinator of the African Trade Policy Center at the UN Economic Commission for Africa. And then I'm joined by Dr. Nagla Nasser, who has extensive experience practicing law, including at ICSID, and as a scholar of arbitration, both municipally and internationally, joining us from Egypt. I have Mr. Gregor Pannike, who is a founder and managing director of Agema Analysts, and routinely advises on institutional and corporate and political risk and intelligence in Africa and other parts of the world. And finally, by Professor Juan Kidane, who specializes in international arbitration and has authored a multitude of publications on international arbitration. Welcome, panelists. And I hope we can dive straight in. We've got quite a lot to cover today. So starting off with Professor Luke, we are going to ask all of the panelists to give us an overview of the African states' key developmental needs from an economic, socio-legal standpoint. What are these needs over the next 5 to 10 years? And how can the international community and its relationship with Africa be used to achieve this goal? Professor Luke, perhaps you could start us off, please.
Yes, thank you very much, Madam Chair. Aisha, good to see you again. And let me greet all my fellow panelists. And let me thank SOAS and CIMAC for inviting me to this discussion. And in particular, let me recognize Professor Emilia Onyema, who has done, I think, an excellent job in getting us all together, regularly updating us on the arrangements and so on. It's been quite easy to prepare for this conference when there's been such a good flow of information. Now, to come to your question, I think we are coming out of a pandemic. We're not yet out of it, and of course, you know that the challenges that we're facing on the continent in Africa as regards vaccination and so on. But we are coming out of the pandemic. We need to return to growth. Before the pandemic, growth levels were quite impressive. But of course, the pandemic affected growth. During 2020, it was negative growth. That has begun to change. We are beginning to see an upturn in the growth figures during 2021. So we need to continue to lay the foundations for the economic transformation of the continent. I would say that this is the most pressing economic issue we need to deal with. And from a socio-legal standpoint, what this means is that we can only transform the continent through market-driven initiatives, and this means through trade and investment. There is no other way of doing this other than through trade and investment, and on the basis of market-driven initiatives. This means that we need to consolidate the African market, and we need to try to achieve regulatory convergence on the African market. And this brings us back to the conversation that was started in the keynote address this morning about the African Continental Free Trade Area and its role in the economic transformation of the continent, in consolidating the African market, and in taking us towards regulatory convergence among the 54 countries on the continent. So let me stop here, and I know that we'll be coming back to unpack these issues, so let me not take up too much time, so you can move on to other panelists and get their opening view of this matter. Thank you very much, Chair.
Thank you. I'd like to invite Dr. Nagla. Please, can you give us your brief overview on what the developmental needs are over the next 5 to 10 years and what is needed?
Good morning, everyone. Thank you, everyone, for attending, and thank you, Amelia, for organizing this event. Thanks, Aisha, for all the effort done to bring this panel together. What should be done? I think the most important thing, we have a very pretty decent document here, but from experience that it needs more than a good treaty to have a real trade between African countries or between any area. Let's community, for example, okay? I mean, they started like with a treaty like that, to make that work and effective, then I don't think they would have gone as far as they have reached today. I'm not sure that an agreement on its own will achieve the dreams of the Africans. The Africans have to start, okay, in a sense that instead of looking to outside the continent, even for investment, they have to look inside. Before looking for, even in simple purchases and sale of goods, we have to look for these goods. We have to have the attitude of preference to our African neighbors. Without that, I think this agreement will not be effective, because at the end of the day, you could have the best agreement on paper, but unless there are people willing to go and do the real job on the ground, it's not gonna be more than ink on paper. This is the first thing. So we have to have, as Africans, a change of attitude. I mean, unfortunately, all of us have colonial history in this country, and a vision of looking outwards colonial power for development, for purchases, for even lifestyle and culture. So we have to have a pro-Africa, use that word, a pro-Africa conceptions in our mind to get this agreement to work. This is the first thing. The second thing, we have to work on not amending or modifying, but on making this agreement always updating, okay? Because, I mean, I'm having a message that the network is not good or something. Is that true, Aisha? Well, unfortunately, I can't do anything about that. The network in Egypt, you know, I have a very big map. Okay? So, I mean, to go back to where I was, is we have to have this attitude that this is not the gospel. This is not the Bible or the Quran. It's through implementation, we can improve on it and upgrade it. So we have to have the constant work on this document, okay?
Thank you, Dr. Sorry.
Yeah, go ahead.
Yeah, sorry. Thank you, Dr. Nagla. I think you might try turning off your video to improve the connection. I think it will improve how you come across.
Okay.
Yes, thank you. So maybe I can turn to, we will come back to you, Dr. Nagla, with the next question, but perhaps I could turn to Mr. Gregor. Your thoughts, please, on the developmental needs over the next 5 to 10 years.
Thank you very much, Aisha, for introducing. Thank you very much, Emilia, for making it happening. And thank you very much for the panelists being here and sharing your valuable knowledge. What is needed? I think there are various tools and various policies and approaches which need probably to be addressed in order to address significant problems in Africa and also unlock opportunities which are plenty here in the continent. I think probably first of all, and that we see, I mean, initially what is much needed and does not apply currently, but also for 5 or 10 years plan, how to integrate Africa properly in a pandemic responsive plan. I mean, right now, I think that Africa and other regions in the world are lagging behind, and this is a major hindrance actually for economic growth, for actually revitalizing the economies here. So I think the world and the Western world in particular need to think how to actually fight jointly together pandemics which happen in Africa. Right now we talk about COVID. So I think this is a very imminent step to have more routine and to see where the needs are from a very basic perspective. Secondly, I think what is very important is how to integrate Africa in the global economy. I think there's still a lot of homework to be done from Western countries as well from African countries, both sides, on financing, on market entry, on how to make sure that within Africa hurdles and obstacles and fragmentation within countries become less. How to increase trade between intercontinental trade in Africa and as well with other regions, neighboring regions like Middle East, Europe, and so on. I think there's a lot of homework to be done, and it's probably not only homework done by Africa. I think this is really a global approach, and can only be done if everyone actually works on that. And there needs to be a lot of support from the Western world institutions, European Union, the US, African Union, to make sure to establish institutions, policies, and measures. And I think the African Free Trade Agreement, Continental Free Trade Agreement, is one tool here on actually overcome fragmentation, on overcoming actually hurdles and trade barriers, and to create a single market, which is much needed, that African countries actually thinking not only trading with foreign regions to Europe, to Middle East or Asia, but actually boosting much needed domestic trade in Africa, which was not possible in the past to that extent, based on fragmentation, different rules, regulations, and so on, and of course, geopolitical and economic challenges facing till nowadays.
Thank you. I'm going to add my own developmental need at the end of this roundup. So yeah, Professor Won, please, what can we add to the things that have already been mentioned by the other panelists?
So just very briefly, at the very most basic level, the infrastructure needs and the gap that exists in every field. And if we're focusing on social legal aspects of the economic needs, it starts from very basic things like law school instruction, infrastructure needs, such as, of course, the needs of each African country are different, but across the board, there's this gap in infrastructure development that has a significant impact on how justice is administered. It starts with legal education, and then there's court management and court docket management, and the level of training that each one of these judges and magistrates receive, the quality of it. And those are very basic infrastructure needs. And of course, if we're going to talk a little bit more about from a social legal standpoint, the legal infrastructure itself within each African country, the constitutional challenges that everyone is facing, not exactly the same challenges, but there are challenges that pervade most African countries in the management of those challenges. And of course, when we talk about cross-border transactions, some of this has already been mentioned, but Africa is not as connected with treaties as, let's say, Europe in terms of judicial assistance treaties, judicial judgment enforcement treaties, any kind of transboundary economic interaction is not sufficiently regulated. We're talking about trade, I'm sure, in the next question, but apart from that, any kind of transnational commerce, the rules, the substantive rules are not harmonized, and dispute resolution mechanisms, jurisdictional issues, enforcement of court judgment actions, all of those things need to develop in the way they have developed, for instance, in the European Union. All of those are in their infancy, and I know OHADA is a little bit ahead of the game, but that could also serve as a model. And when the Continental Free Trade Agreement comes into effect, it would, I believe, have the capability to facilitate a harmonization across all fields of law.
Thank you. So I just wanted to add to what's already been said. On my end, I think one of the developmental needs is better Wi-Fi across the continent so that we can have better communication and discussions around these issues, because I often face the same challenges as Dr. Nagla. Turning to our next question, what are the challenges that we face on the continent? I know a number of you mentioned this. Is there a need for change? I think the answer is yes. I'm going to start with Dr. Nagla, and then I'll turn to Professor Won to talk about why the Africa Free Continental Trade Agreement may or may not be the solution to meeting these challenges. So Dr. Nagla, over to you about challenges, please.
Challenges facing this agreement is basically, and most importantly, building the human capacity to handle that. You build institutions is very important, but institutions are run by individuals. You have to have human resources building to get this agreement off the ground in a proper way. Secondly, and more importantly, as I said, is you have to create the mindset of Africa trade. And this is very important. African countries have to take an active, proactive role in promoting foreign African investment. This could be done through different means and different channels, but I am one of those believing that Africa investment, and I'll come to that later on impact investment, should be given a preferential treatment, should be put in a certain category to encourage such investment, okay? I don't want to go into politics, but without a stable political regimes, you cannot have economic achievements. This is evident. So Africa has to, if they want to have this agreement more than ink into paper, they have to work on stabilization of their political regime, or at least to put their political differences aside when it comes to investment and economy, okay? Because it is very important not to mix the two, and that decisions on investment and economy is done on purely economic basis without, you know, we all know that politics create artificial frictions, okay? So this is very important. From my point of view, these are the three main challenges. Thank you.
Thank you, Dr. Nagla. So Professor Won, what do you think? Is the treaty capable of offering a solution to the three main challenges mentioned, or anything else you think we ought to put in the top category of challenges?
My initial understanding of the question was the challenges that the treaty itself faces going forward. And I wasn't sure if there were three identified, but to me, there are external and internal challenges to the implementation and meaningful rolling out of this treaty. And what I hear from and read from my trade law specialist friends is primarily its coexistence with existing obligations and what's happening externally to, I don't want to say undermine it, but to take away some of its vitality. An excellent example is something that Professor Malaku Desta has recently published about the economic partnership agreement that is being considered and is under negotiation. And related to that, unilateral action that each one of these African countries might take. And those are the types of challenges that I see could, this could be deeply technical, but the internal ones obviously is the efficiency and the capability and the desire to implement each one of the provisions of the agreement and the speed at which all of these could be implemented because of the infrastructure gap, the knowledge gap that has been mentioned earlier. So it's a broader problem, but the process has been started, and I think through time, many, if not most, of these challenges would eventually be overcome.
Thank you, Professor Won. I think the question was slightly different, but I think, Professor Luke, you're going to help us with why do we need this Africa Free Continental Trade Agreement at all? It's extremely ambitious in scope, covering not only trade in goods and services, but investment, intellectual property rights, competition policy, e-commerce. I mean, it's extremely broad for a continent that's really never come together before in this type of way. Perhaps you can go into why we need it.
Why do we need the AfCFTA? Think of it this way. Africa is 54 countries. Together, these 54 countries have a continental GDP of something like 2.5 trillion US dollars. It has a population, continental population of 1.2 billion. So it's a substantial market. If you compare Africa with India, you find that these metrics are almost the same. India has a GDP of about 2.5 trillion US dollars. India has a population of 1.2 billion people, but India is one country with one public policy framework, one regulatory regime, whereas Africa is 54 countries with 54 public policy frameworks and regulatory regimes. So why do you need the AfCFTA? You need somehow to overcome this fragmentation of the continent. And this fragmentation of the continent is a legacy of history. This is the reality that it's part of our history. And the way that you can overcome this fragmentation is to try to build a market across the continent. It's not easy, and I think from what everybody has said, there are challenges there. But at the same time, it's a dynamic situation, and I think African governments are to be applauded for what they have achieved so far. This idea of a continental market was not something that was imposed on African governments from outside. It's an initiative that came from within Africa to say that everywhere you trade with your neighbors. But we have not been able to do this because of the of our history. So this is what this effort is about. The challenges are huge, yes, from infrastructure to low trade volumes to productive capacity issues, etc. But as I say, it's a dynamic situation, and we're seeing an improvement over time. For example, in 2010, intra-African trade was about 11% of Africa's total trade. In 2019, just before the pandemic, it was 16% of total trade. And there are projections, including from the Economic Commission for Africa, work that I did before I left with colleagues. There are projections that this can double under the AfCFTA if the AfCFTA is well implemented. So why do we need the AfCFTA? We need the AfCFTA to respond to this fragmentation of the continent, to respond to this issue of low trade among African countries, and to recognize the reality that in every situation you trade with your neighbors. You don't trade only with faraway partners. Even from the most basic societies, if I'm a hunter, I go out, I get some meat, I come back and I exchange my meat with my neighbor who's a farmer and who produces grain. So all societies trade with their neighbors. We find this in Asia, we find this in Latin America, in North America, Canada, US, Mexico. We find this, of course, in Europe, classic case. All societies trade with their neighbors. And I think the British, having left the EU, are finding how difficult it is when you take this kind of a decision, because that's the reality of the way that trade works. So
thank you, Professor Luke. I think we're going to come and touch on to some of the other points you are going to develop in our questions. I just wanted to clarify that we actually have 55 countries in Africa and only one holdout in terms of signing the agreement. And we must all do advocacy on our holdout neighbor who is close to us in East Africa. Next question, please. How does harmonization and alignment of African legal systems, laws, and regulations help us to address one of the key treaty objectives of creating a single market in Africa and deepening economic integration in accordance with the Pan-African vision of an integrated, prosperous, and peaceful Africa, which is part of Agenda 2063. For this question, I'd like to start off with Gregor, please.
Thank you much, Aisha. Now, for creating a single market, I mean, you need very simply to set the rules of the game, right? It's an example. If you take the European Union, hasn't been established overnight. So it was like, over a couple of decades and different agreements, different integration processes, different harmonization, and the different adoption by various EU members and non-EU members. Take Switzerland is not part of the EU, but still adopting most of the EU regulations. Now, if you take this more or less as a sample of a case, which works quite well. Now, African development, and this is what I mentioned at the beginning as well of my elaborations on the needs of integration. Now, the globalized world needs more harmonization. Now, if I'm an entrepreneur and I would like to do business in Kenya, and then I have a completely different set, rules, regulation, dispute resolution, IP protection, take any of those, and to adopt again in Nigeria, whereas if I invest in Berlin or in Paris and I have probably similar frameworks, this for me as a global player makes Europe just much more favorable, even though Africa has probably more to offer, because it's just a hindrance, it's just a barrier. Now, if I have to assess 55 different customs regulation standards for which plugs I use, and so on. Now, all those are trade costs, which increase my costs in trade for a German company, for a French company, for an Emirati company to come to Africa. So, I think it's very, very important to really define the rules of the games. The African Continental Free Trade Agreement helps or gives a guideline, and I think is what Nagla as well mentioned. It's a guideline only on paper, and I think there's a goodwill behind that, which needs to be implemented by centralized agencies, properly monitored and implemented in each and any jurisdiction. And harmonization has to be lived. It will be an exercise for many, many decades probably to reach that. But I think the journey has to start as soon as possible, and to have a mindset that Africa should be one trading area, similar to the European Union or any other trading areas in the world, and has to live it up. And yeah, so I think this is one of the main objectives, and I think then we can see significant growth. What David just mentioned, domestic trade within Africa can grow, and not actually looking at the neighboring markets, but I think what I mean is beyond Africa, but within Africa. And I think this is a change of mindset, a change of appreciating intercontinental trade and seeing opportunities and advantages in various jurisdictions within Africa, and making no difference between Sub-Saharan Africa, Northern Africa, Southern Africa, Eastern or Western Africa.
Thank you, Dr. Nagla. I think Gregor has mentioned one of your favorite words, which is change of mindset. What would you like to add to how this treaty can help us?
Harmonization is very important for Africa investment more than the outside world, because when you have a harmonized legal system, the fear of the unknown, does not exist. People do not like to go where they don't know a legal system, where they don't know the rules of the game. So when we will have a harmonized and aligned African legal system, it will require us, it will change our mindset. Why go to England where, for example, we are civil law countries? Why go to England if I know for definite that though Nigeria is a common law system, I know their laws So I will invest more in a legal, where there is a legal system that I'm familiar with, and I have a feeling that I can handle. The fear of the unknown will disappear. Secondly, and equally important, that harmonization level the playground. And instead of having African countries compete with each other, it will let African countries complement each other. Okay, and this is very important, okay, in attracting investment. So if I know, for example, that I am doing a project where the feed-in, stock feed-in, or the natural resources I need is in another African country, instead of sticking to my own territory, which is Egypt, Nigeria, or anything, I will just go to this other African country with their legal system. So it, at the end, instead of competing with each other, will complement each other. And that's very important in promoting Pan-Africa investments. Okay, thank you.
Thank you, Dr. Nagla. I'd like to ask Professor Luke. One of the things Dr. Nagla has mentioned is that we need to look beyond the treaty, the paper treaty, and how to operationalize these objectives. Obviously, there are a number of challenges towards operationalization. Maybe you can take us through some of the bottlenecks that need to be addressed so that the treaty can become successful.
Yeah, in terms of operationalizing the treaty, yes, of course, you know, at the most basic level, the current negotiations on goods and services need to be finalized. As I understand it, about 95% of the work on rules of origin have been completed, but you know, there's about 5% remaining to be done. Similarly, on the on tariffs, the modalities for tariff reduction have been agreed. You know, the modalities say that 90% of tariff lines will come down to 0. 3% would be reserved as for countries that do not want to liberalize those tariff sectors, and 7% would be phased over a period of 15 years. So now we need to finalize this to have the new tariff schedules published so that everyone knows exactly what products in which country, etc., can enter tariff-free, and what is reserved under the 7% and what's under the 3%. So I think all those basic things need to be done. On services, it's already been agreed that the baseline is the commitments that African countries that are members of the WTO have already made, but they need to improve on their offers at the WTO in the service sectors that have been selected for early liberalization. So that also needs to be done. But as I said, it's a dynamic situation. For me, the most hopeful part is the fact that when you look at the composition of intra-African trade, you find that it is over 60% of intra-African trade is actually value-added products, as opposed to about 80% of Africa's trade with the rest of the world, which is just commodities. So what this tells you is that if we can be successful in building this market, finalizing these technical areas that I just mentioned, the potential is huge. And also when you consider that currently average tariffs across the continent is about 8%, when Africa exports to the rest of the world, average tariff is just under 2%. So I think that makes a substantial difference to bring tariffs down to 0. So the incentives, and markets always work on the basis of incentives. The incentives, I think, will give a big push to help to realize the treaty, so that it's not just a paper treaty. Let me just end with one point, Aisha. The United Nations recognizes 54 countries in Africa. The Sahrawi Republic is not recognized by the UN. It's recognized by the African Union, but not by the UN. So when I said 54 countries, I was speaking from a UN perspective. But of course, you know, from an AU perspective, there are 55 countries, just to clarify this for our audience. Thank you.
Thank you, Professor Luke. That's an interesting point you're making about when we talk about Africa, are we talking as Africans about ourselves, the way we understand each other? Or are we outward facing and talking about how Africa is perceived by the rest of the world? That's a broader question, but thank you. I'll still come back to you, Professor Luke, because the next question is about the role that key stakeholders can play in improving the chances of success of this treaty. You mentioned one key stakeholder, which is the WTO. There is the fact that there's an international playing field for global trade. Maybe you can talk us through key stakeholders as you see them in terms of success.
You know, certainly, I mean, you know, again, you know, the key stakeholders, I think, in terms of success is African traders, African investors, African civil society. Increasingly, trade policy is becoming more and more complex. It's not just about trading goods and services, it's also about the environment, how trade affects the environment, how trade affects climate change. It's about who benefits from trade, how inclusive trade is, and indeed also increasingly looking at inclusion also from a gender perspective. The extent to which women are also benefiting from market opening and so on. So I would say civil society has a strong stake in this, along, of course, with the economic players. But outside of Africa, and we come back to sparring between us about how the rest of the world sees Africa and so on. You know, outside of Africa, yes, of course, you know, global institutions like the WTO, the UNCTAD, the ITC can all provide technical support in terms of analysis. We need actually to analyze the impact of the AfCFTA, what is changing on the ground and what is not changing. So I think all of these institutions can assist with that, as well as, of course, academics who are doing their own research and so on. But we need more information, more data on what's actually happening on the ground. And then, of course, our development partners, international financial institutions, all have a stake in this. Trade, the other side of the coin of trade is, of course, investment. I think this has been touched on. And you will not have much happening without investment. So you need also investors have a stake in this. And of course, the African market, I talked about incentives in creating a larger market. It makes it more interesting for investors because they can achieve scale economies, economies of scope and so on, which makes for better returns to investment. So I think these are just part of the cast of players that have a stake in ensuring the success of the AfCFTA.
Thank you, Gregor. I don't know if you wanted to add anything in terms of what role key stakeholders can play in terms of increasing the chances of success.
Absolutely, thank you, Aisha. I think David summarized it very nicely and comprehensively. You know, from my humble knowledge, you know, from African economy, I think what is very, very important is, and in particular, you know, if you take Eastern Africa or Kenya, it's private sector initiatives. Now, the private sector plays a significant role to push government and government agencies and policymakers actually, and to shape actually the way and to pave the way for the implementation of the African Continental Free Trade Agreement. There's a lot of work to be done. Of course, I mean, external partners are very important. Might it be on a multinational, might be binational basis, might be actors which have very strong commercial relationships with certain regions in Africa. But I think the private sector is definitely a key player here to drive actually the implementation, because it's their own interest to get this done, to create actually a single market, and to convince and talk to government agencies to ratify, adopt, and implement all tool sets which the African Continental Free Trade Agreement provides, and to promote actually a single market.
Thank you. I think on the private sector, academics, I think Dr. Emilia had already made a request about getting access to some of the draft documentation, which seems like the response will be very limited information. Maybe Professor Won, we can turn to you. What innovations to international investment rules will the proposed investment protocol introduce for us Africans?
Thanks, Aisha. So the investment protocol offers an excellent opportunity to introduce some innovations to international investment law generally, and also specifically to the African continent. I can think of at least 3 areas where there could be innovations. The first, obviously, is on the substantive rules of international investment law. And as we all know, there has been significant uncertainty about some of the most important principles, such as the fair and equitable treatment, MFN, expropriation. So the treaty, this protocol could lead by helping in the ascertainment of the outer limits of these principles. I know there is some suggestion to get rid of some of these basic principles, such as FET. But instead of doing that, I think the convention, there is some models that they, like the Canadian model and others, that have tried to elaborate on what these principles mean. But the African protocol could even go beyond that and include not only what these principles mean or what they do not mean, what they include, what they do not include, and could go as far as incorporating some of the desired jurisprudence into the treaty. It's something that hasn't been done so far. So that is something that could happen in terms of, as I said, the ascertainment of the outer limits and the scope of application of these basic principles in identifying their substantive content. So that's one area. Second area that it could be helpful is obviously the procedural aspect of it, including dispute settlement. One possible innovation is the interlinkage between trade dispute resolution mechanism and investment dispute resolution mechanism, the leveraging of the existing trade investment infrastructure, trade dispute settlement mechanism to sort of help with the investment dispute settlement also. In the ISDS, whether Africa wishes to get rid of it or not is something that we will wait and see in terms of its political feasibility or desirability. To me, I think some type of investment dispute system mechanism should exist. And without that, the substantive principles would be meaningless. Whether we go in the direction of maintaining the existing form of ISDS, a court system, which is very unlikely, or ISDS with an appellate mechanism that the Group 3, UNCITRAL Group 3 is discussing. But in any case, Africa could try to introduce some innovations there. And something that has already been done under the Pan-African Investment Code is possibility of adding counterclaims, whether through treaty or investment agreements, and the mechanics could be worked out, private right of action, and possibility that host communities may have standing in the same type of proceedings, including possibility of consolidation of contracts-based claims, treaty case-based claims. It's a combination of all of these, including perhaps some innovation as to how arbitral awards could be enforced against private parties. And of course, substantively, as I probably did mention, the obligations of investors should be defined in some ways, and this is something that the Pike draft has already introduced. Finally, I don't want to take too much time, the innovation could also relate to the coexistence of the new protocol with pre-existing commitments and how existing ones could be phased out so that the principles enshrined in the new protocol would be the only governing principles. That could happen in a wide variety of ways that I can think of, but primarily is having that commitment for each one of the African countries to replace, obviously the intra-Africa ones could be replaced outright, but the external ones could be phased out. There might be an obligation that they have undertaken under the protocol to phase out their external investment treaties and try to harmonize everything else across jurisdictions. So those are opportunities for innovation that I can see. I know some of these are very difficult questions, but as I said at the beginning of my remarks, the opportunity presents itself. I think Africa should seize those opportunities and lead by example.
Yeah, thank you. Those are interesting points around innovation. Dr. Nagla, coming back to you, and I think we've touched on this earlier, but you know, what is the role of the treaty in promoting intra-Africa investment? This is a key part of the treaty, and I think a number of speakers have touched on it. Did you want to add anything on this topic?
Yeah, well, I mean, Professor Luke have touched upon it. I mean, this treaty has to benefit the grassroots, what I'm saying. And unfortunately, the treaty, or fortunately, have not directly dealt with the concept of making profit through purpose, or what we like to call, this is a nutshell definition of impact investment. I mean, we should in Africa look for investment that benefits have social and generate measurable beneficial social or environmental impact. It is not, this is not the era for only looking for investment that creates profit or that creates job opportunities. This is very good, but now we have to give consideration and preference to investment that impacts the environment and development. And that's why we call it impact investment, okay? Where the marginalized, marginalized, I don't want to use social classes, where the marginalized individual in any society could develop through it. And we have been seeing that a lot in recent years. And in fact, it's a very growing big business. I have like some statistics here, which says that it grew from around 50 billion to 500 billion in the last few years, taking into account that the last few years have seen a recession and the pandemic. This is a very impressive rate of growth. So I would love to see this agreement being applied in a way, in spite of the fact there is no express provision to that effect, apply in a way to promote impact investment in many sectors like health, housing, and many other sectors, you know, creating smaller industrial bases to benefit the poorer rural areas. All these plays, education, agriculture, all these sectors, you could have investment that creates profit, but has a purpose and allows the society or these like marginalized communities to benefit and to develop. And this is very important for the success of any instrument, the more the beneficiaries from it, the more the success chances of it. And this is the secret behind the European Union. I mean, the individual benefited from it on all levels. It's not the big corporate or the big businessman. So that's what I would love to see happening in real life when this agreement is applied. Well, I'm one of the big enthusiasm for impact investment. Yeah. So, you know,
thank you. I hope you'll be asked to design. I hope you'll be asked to help design the tool that measures success, so that you can include.
We need new tools. I mean, obviously, the agreement just put a frame for promoting trade, but we can create the tools to make it more effective. So we can create tools having in mind that profit is not the only goal, creating jobs is not the only goal, and that we have to have a purpose of any investment. Thank you.
Thank you. Yeah. So turning now to our next question. How does robust, transparent, effective cross-continental dispute resolution promote industrial development, diversification, regional value chain development, agriculture, and food security? I'm going to first turn to Gregor for this, please.
Thank you much, Aisha. Now, any investor, anyone who wants to enter a new market or is a market entrant and want to maybe expand their operations, requires legal certainty, requires clear procedures. What's happening if something goes wrong with a joint venture partner, with a distributor, or any business partner you probably have an agreement with a supplier, vendor. Now, dispute resolution, hopefully it will never happens to most of the transactions, but it does. And investors will shy away, or they will be more prudent in business decisions, and hence will not promote industrial development, will not contribute to diversification in certain markets. Like, for example, an American company sees a great opportunity in Gabon or in Nigeria, but it's just shying away because he doesn't believe in a dispute resolution, and it may be the arbitration, and just imagine that the specific country in Africa is not very favorable actually for foreign arbitral awards to enforce it in their jurisdiction. Now, all those repercussions or impacts of having a non-transparent, a non-effective, or probably even in some jurisdictions a not wanted approach to arbitration, which is mostly used for high-value contracts and commercial disputes across jurisdictions between international partners. This has definitely an impact on local economies. Now, what will contribute having actually a properly functioning dispute resolution mechanism across different jurisdictions, and being clear if you go to court and both parties know what will be happening if I do not live up to the provisions of the agreement, or to certain arrangements I had, contractual arrangements I had with my contractual partner, that there will be more discipline, there will be a better enforcement, and there will be a clarity actually what will be the cost in case a transaction doesn't go the way both partners want. So there's a direct linkage between having a transparent, robust, and effective dispute resolution mechanism across Africa, and economic impact in various sectors.
Thank you. And on that note, we turn to our expert, Professor Luke. Can we pick up on that, the linkages? And I don't know if you wanted to mention specific parts of my question, which was the value chain development, maybe food security.
Yes, let me unmute myself. Thank you. Yes, indeed, just to follow up on that, you know, I think value chain development is one of the expected benefits of the AfCFTA, and we're beginning to see this happen already in some sectors. If you take automotive, the automotive sector, you're beginning to see intermediate components being supplied, you know, by several countries to the main manufacturing hubs, which currently in South Africa and Morocco, but other smaller hubs are beginning to emerge, such as in Ghana, in Kenya, in Rwanda. But you're beginning to see components ranging from seats to chassis and so on being supplied across the value chain. And other studies that I've seen relating to, for example, leather, cotton, textiles, and so on. Again, you're seeing intermediate components being supplied across the value chain. Let me also say that regional value chains will develop and grow in parallel with global value chains. In fact, the way that production occurs now does encompass both, where you could have inputs coming from outside the continent, and so, you know, through global value chains, and you can also have inputs coming from within the continent. But I think the most important thing is that that we see that is beginning to happen is greater clarity. I think this is something that all the panelists have mentioned, so that investors, business persons, entrepreneurs have a good sense of what kind of strategy to adopt in terms of production on the continent. We also tend to think more about goods, but I should also say we should be thinking about services as well. And on services, also we are seeing integration happening, especially the financial sector, which you know, has shown tremendous innovation in terms of how the regional financial institutions have diversified their product range, and in terms of the number of countries in which several of our financial institutions, banks, and so on now operate. And also we are seeing this growing interlinkage between the financial institutions and the communications institutions. And also we're seeing the kind of innovation that comes out of that. And of course, I see Aisha is nodding because you're sitting right there in Nairobi, which is the home of M-Pesa and so on. But, you know, right across the continent, we're seeing this kind of innovation coming out of the communications systems as well. So yes, indeed, you know, and all of this is contributes to value chain development. Of course, the financial system is critical as the means to which financing and investment can be channeled. So I think all of this bodes well for the way that the AfCFTA would be implemented. In fact, let me go so far to say that my sense is that the private sector and private investors are way ahead of the government policy making framework and regulation. In fact, I think what we're seeing happening is that the public sector is now trying to catch up with the dynamism of the private sector. I think this is really what we are beginning to see. And I've seen some recent surveys, including how digitalization has expanded during the pandemic, which seems to suggest that many African businesses turn to online solutions because of the lockdowns and so on. And still, when you look at the whole area of digitalization, there are huge policy gaps. Of course, the AfCFTA does have provision for a protocol on e-commerce, but that is at least 2 or 3 years away. And we know that on the ground, our entrepreneurs are not waiting for the regulators to catch up, but they're already doing their thing. So, so I think that's the reality that we are seeing on the and all of this, of course, contributes to value chain development. Thank you.
Thank you. And I just wanted to invite Dr. Nagla on this issue of how an effective dispute resolution mechanism can help with development. You've mentioned, you know, we have to also look at the grassroots and make sure everyone is benefiting, not just the elite, but those of our normal citizens who face challenges. What do you think about this?
Well, I mean, effective dispute resolution is very essential, and the sense of justice is very essential to promote any economic goal, be it foreign investment, be it trade, be it internal investment, and encouraging saving. So it goes without saying that without an effective cross-continental dispute resolution mechanism, it will be very difficult, even if we level the ground, like I said, and even if we become complementing and not competing to each other, to convince a foreigner to come and invest if he has a sense that when a dispute or a disagreement or a difference, even something small, arises, justice will not be done for him because he's not from the locality. And unfortunately, this fear is the courts cannot properly address, even if the courts are very independent and impartial, because this is something ingrained in human beings. So having effective arbitration mechanism is very important to promote a sense of justice and a sense that wrong will not be done, and if it's done, it will be resolved in a justifiable way. And this in itself encourage people to move from their locality and put their money somewhere else where it is more beneficial for them. But sometimes they just elect to forgo an opportunity because this very small reason. So I think it's indispensable having a strong, robust arbitration system. We've heard about it. Whether we've heard, like in the morning, Her Excellency the Ambassador Nagla, and we have to get this going, even, I don't want to say before, but in parallel to encouraging and working on the other issues, because without it, I mean, I doubt that anyone will leave his locality where he's secure, well connected, knows what will happen. Okay.
I think the difference in Africa is some of us may be moving from countries of instability and investing in our neighbors that are actually more stable. So it's not always that home is best, actually. Gregor, I'd like to invite you to talk to us about why and how a robust IP protocol would enhance the competitiveness of member states to this treaty, both on the continent and in the global market.
Thank you much, Aisha. Absolutely. Now, I think similarly important, what we just discussed about effective dispute resolution. Another major factor for competitiveness of economies and regions is definitely IP protection. Now, just imagine any innovation, any disruption, any knowledge transfer, which comes to a region, and there are plenty of examples. I mean, just take the Emirates, the UAE, for example, which is on a very, very exciting expansion investment of technology and driving data sector, could only be possible since the UAE actually has implemented very strong IP protection regulations, enforcement, fighting against counterfeit products, and so on and so forth. Now, any startup which is very vibrant here in Nairobi, in Kenya, or even in Nigeria, will think twice if they should venture into a market and provide the technology solutions. And there are many unicorns we have seen. They're creating a lot of jobs. They're creating a competitive edge. And we just mentioned M-Pesa. It's just, you know, one of the big success stories here in Kenya. Now, those disruptions, those innovations or developments will only be possible if they know that their trademark, their copyrights, the formulas, whatever IP class of IP right, you know, it more or less identifies, is probably protected and can be actually prosecuted, because otherwise, you know, they will not just enter the market and would actually shy away. So it's a very basic principle. IP protection, along with dispute resolution, that we discussed before, are very, very crucial in actually bringing an economy forward, diversifying an economy with different technologies, methods, means, coming from other countries, coming from homebreed startups, from homebreed bright people, what we're having here. And I do work a lot with them, and it's amazing. And if they cannot protect their IP rights as much as they want, they would not consider actually extending their business, investing in a country, or even expanding their operations into another neighboring country. And yeah, I think that's pretty much sums up.
Thank you, Gregor. Now we are going back to all the panelists for some sort of roundup before we can open up to questions from the audience. So the first roundup would be asking everyone to comment on the possible obstacle and challenges in a comprehensive implementation and enforcement of the treaty and in achieving a single market. So we've heard a lot about the challenges. We've heard a lot about some of the potential solutions. If the panelists could limit themselves to no more than 2 obstacles, just so that the last person has something to say. I would like to start with Professor Luke, please.
Yeah. Well, I would not say an obstacle as such, but I think, let me say, a couple of prerequisites, or if you like, challenges. The first is that each country really must have its own national strategy in place as to how it wants to utilize this continental market. I already mentioned that there's a lot that is happening on the ground by African entrepreneurs and so on. But this has to be put in some kind of a framework to enable targeted support, to leverage what is already happening and so on. So I think that's going to be key, the country strategies. Then the second challenge or obstacle, as I see it, is to scale up investment. I'm very happy to hear Nagla already talk about this issue of investment. And indeed, we've seen an upward trajectory in incoming investment, as well as in intra-African investment, by the way. But we need to scale this up because, you know, very clearly, we need to extend and build productive capacities. That's what this whole agenda of economic transformation, industrial development is all about. And for that, you do need to scale up investment. So I think for me, these will be the two key issues that I would highlight. Of course, there are many more, and I'm sure that Gregor, Juan, and Nagla will be elaborating on all these points. Thank you, Aisha.
Thank you. So now, Professor Juan, please mention one or two of what you think are the key challenges or obstacles to be overcome.
Just at a, again, basic level, there's the challenges of internalizing or domesticating these treaty provisions and creating the proper domestic legal infrastructure to make sure that it actually gets implemented. So that seems very simple, but basic, but sometimes it takes years for states to be able to create those. And the other one is to obviously resist the temptation of derogation from it because of other collateral agreements externally. And that's something that I mentioned earlier. So that I think so many of my colleagues think that that's probably one of the greatest challenges. We hear bilateral arrangements here and there with the global north that obviously would have its own impact when it gets implemented, and the harmonization of all these rules could be challenged at an individual basis, and also would have an overall impact of undermining some of these basic principles enshrined in the agreement itself.
Thank you. Dr. Nagla, can you take us through one or two?
Yeah, I think we need capacity building, including institutions. We need to harmonize our policies, economic policies, I'm not speaking about political, and laws. Keep our economic goals separate from our political differences, and to create the right human being with the right frame of mind. And that's need education to overcome obstacles created by our joint historical realities. I mean, we cannot overturn history, but we can educate the new generation to believe in what this agreement is trying to achieve. A very clear example in Europe is France and Germany. The old rivalry and animosity between them did not impede the creation. In fact, they are the two founders of the Rome Treaty and the Cold Treaty. So that's what we need here. That's what we need here. And this is education, training of the young generation. Thank you, that's all.
Okay. Thank you. And Gregor, you've gone from molding a new human being and changing their mind. I'm not sure what's left for you to mention.
Probably two points. I'm not sure if they add value, but I will try. I think probably the first obstacle, the first challenge of implementing it comprehensively throughout Africa, the agreement, would be geopolitical tensions between countries and the willingness to implement. We see in Africa, unfortunately, and a lot of, and we see it in our neighborhood here in Eastern Africa, political tensions, geopolitical tensions, which have a spillover effect to other countries, which create tensions and willingness to align and to cooperate actually on implementation, harmonization, and reducing fragmentation between countries, within countries, and within regions. And I think the geopolitical aspect, I think, should not be underestimated, which come from the outside as well. We have many actors who are interested in the Horn of Africa, not only from the Middle East and Asia, but other parts of the world. And they might have a different agenda. They might have a different influence on the governments implementing the contract. So I think geopolitical aspect definitely needs to be taken in consideration. Secondly, I think another one is efficiency of agencies, and I think Professor Nagla at another point with capacity building is lack of resources. So there might be a lack of willingness from agencies, complacency actually not to enforce it, but there might be as well lack of resources. I mean, resources after COVID and right in COVID, many governments are stretched. There needs money and people, experts, expertise, policies, procedures to be implemented to make the agreement reality. Now, where the money comes from to establish those resources and create capacity for absorbing and to establishing actually those procedures to make sure they're in a harmonized way implemented. So I think those two aspects are very critical, and not the only ones, but I think very critical on a successful implementation of the free trade agreement.
Thank you. And so starting in, I guess, I mean, a follow-on from what you've just said, it's slightly asking the question in a different way. Gregor, you've mentioned some of these big challenges, some people, some of the actors being outside the continent who might have an agenda that is not aligned to the treaty. What might the possible solutions look like to these challenges?
I mean, just addressing probably the both points I just mentioned. I think going first to the geopolitical part, it's a very deep question, and I don't think I'm in a position to give a comprehensive or complete unsatisfying answer. But just my personal opinion, I think nation building, peace process, and integration and communication and alignment, and we see right now the conflict in one of our neighbors here, unfortunately, and many other jurisdictions. I think it's really like everyone who has a stake, not only the African Union, the European Union, donors should actually have a positive impact and a positive ambition actually to make sure that the African Continental Free Trade Agreement is going to be a success, that Africa succeeds, that there will Africa, that we're living here, that we are not subject to any donors, actually to any other outside support, that Africa actually as one of the richest and could be most prosperous continent, should actually promote that and stop dependency from Europe or from Western world, and hence actually change their geopolitical agendas. But even also it applies to the Middle East. I mean, the Horn of Africa is deeply impacted by geopolitical agendas and interests, for example, from the Middle East, from the GCC and other countries, and disputes happening there. Now, I think so. This definitely, there should be a positive impact. The funds provided should be in capacity building, resources to make sure that politicians locally understand the message and actually promote the implementation, and not only follow domestic agendas which are not promoting such trade. And secondly, of course, capacity building can only be happening if you have resources, if you have funds, if you have expertise, and there are other states actually can come in. I mean, we have in European Union well-working, or more or less well-working bureaucrats sitting in Brussels, and there's technical knowledge where people can transfer knowledge and actually support and help agencies locally to implement, adopt processes, and how such systems and structures are to be built up, and this could be actually a very, very effective way to train local and vocational training and train local experts, and to leave it really to African implementation by African actors. And I think this is what's wanted without having too much dependency on non-African actors.
Thank you. We've got about 6 minutes left before we open up to questions. Professor Won, what do you think we can take from other successful single markets and adopt in Africa? What key lessons or takeaways should we be taking from outside and adapting to our African context?
So I'll focus on my own specialty in transnational commerce. So, for example, the cross-border harmonization of rules across Europe, for instance, the Brussels Convention, for instance, whether it is the enforcement of arbitral awards or the enforcement of court judgments. And there isn't such a thing in the African continent. So one of the things that the Continental Free Trade Agreement helps is in bringing these nations together, at least with respect to trade. That would obviously have a ripple effect, and it facilitates transnational commerce of all types. And of course, when you have transnational commerce, the rules need to be harmonized, probably in a treaty form, including mechanisms of dispute settlement that has been mentioned earlier, including the enforcement not only of arbitral awards, but also court judgments, and the harmonization of contract laws, tort laws, or all of those things. So those are the ones that come to mind from just purely technical standpoint.
Thank you. Dr. Nagla, I think you mentioned some of the other successes in places like Europe. What do you think for you is the key takeaway that we might want to adopt in Africa, looking outside?
We have to learn, and that's maybe a big difference between the NAFTA and the European community. We have to learn to treat each other as equals, okay? And to learn to put our difference aside to realize our joint economic goal. And that's a very important takeaway from successful experiences in this area. Okay? Maybe, I don't know.
Sorry, can I just ask you to elaborate? You mentioned that's a key difference between NAFTA and the European Union. Which one is more successful and why?
For me, and that's only a personal view and evaluation, I think the European community, of course, the European community idea and development is a much older institution. However, it's more successful in realizing that prosperity of the European people via economic goal, because I think the Europeans took a decision to treat each other as equal so long as you are admitted, okay? They don't, unlike the NAFTA, where the different economic development between Canada, US, and Mexico, I think have played the role in slowing down the economic benefits and making and limiting the impact of the agreement, which is not so much felt by the average individual, like, you know. So, I mean, this is what we have to learn, that our agreement should, via implementing it, should we should put our differences aside, treat each other as equal to benefit, so the benefits could go to the average individual.
Thank you. And then Professor Luke, you have less than 2 minutes, please. Can you give us a key takeaway or lesson you think we can import from other successful single markets? Sorry, you're on mute. You're on mute.
So, sorry about that. Yes, indeed. I think already the AfCFTA has consciously borrowed from the way that other trade agreements are structured to ensure that best practices can be followed. We see this, for example, in relation to provisions on trade facilitation. For example, and here let me just note that there's a question from Abdallah Ali. I guess we'll be coming to this in the next segment that touches on this issue. But yes, and also in terms of creating the kinds of institutions that are needed for regulatory convergence, I think the AfCFTA is looking at what has been done in other contexts and to see how to domesticate this in the African context. So, in short, I would say that the AfCFTA has benefited from being a latecomer to the table. And by being a latecomer to the table, it means that you can borrow ideas that have worked elsewhere and see how to put them into practice. I think much of what we heard this morning from the keynote speaker, basically the way that the dispute settlement system has been set up, we can see that it encompasses ideas that have been borrowed from what has worked elsewhere. So I think from that point of view, we can be hopeful that we'll begin to see results from consciously adopting what has worked in other contexts.
Thank you. And now I'm very pleased to announce that's the end of our scheduled questions, and we're open to the audience asking through the Q&A function on the Zoom screen. Please feel free to put your questions down and nominate a speaker. Otherwise, panelists are free to volunteer to answer. I believe we have two questions at the moment. The first one is to all panelists. We have mentioned the roots of colonial legacy as impacting on how African states behave. How exactly can we overcome this legacy through the African Continental Free Trade Agreement? So I think this one, given previous comments, I'd like to invite Dr. Nagla, please, to answer.
Well, I've said it's education and education and education. You cannot overcome history, you cannot reverse history, but you can educate people to get out of it and of the legacy that you inherit, and it's over your shoulders and pull you down. And there are many, many successful countries that managed that around the world. Japan or Germany. So if your historical, if your history is an obstacle or your colonial history is an obstacle, then I think the only way is education. Education that changes the frame of mind, that changes the way people think and view history, and to accept that we have to be critical of oneself. Okay, so it's education, my simple, and there is no quick way to do it, in fact. There's no quick way, there is no magical way to overcome history, okay? But I mean, over generation, if you have the right education, you can gradually get out of it. Okay, thank you.
Thank you. Does anybody else have anything to add to what Dr. Nagla said on how we can maybe overcome these challenges based on our colonial history?
Maybe if I'm maybe add some comments on that. I think what is crucial actually that ex-colonized countries are aware of their own identity, create their own identity, independency, not only from a cultural perspective, but also from economic perspective, government perspective, and influence, and in defining their own independent policies, objectives, missions, what they try to achieve. If you look from the Middle East to North Africa and Sub-Saharan Africa and South Africa, international organizations and governments are important in nation building, important to support, but I think there should be also a line drawn to which extent governments or institutions have influence. And this, you can see mostly because based on the history in those countries. And I see here, for example, some countries in the eastern part of Africa as well, who go their own way, who are prospering, and who are actually doing fine. And I think it's a really a fine line between cooperation, but even defining own policies, and having the right balance on politically and diplomatically on how to approach that.
Thank you. I just maybe wanted to add one or two thoughts from me on this point of education. I think the education or the re-education is required not just for African states and citizens, but also for our global partners. So I would say that recently, you know, Secretary of State Blinken is visiting the continent. One of the notable features for this visit is that the condescending rhetoric that we were used to receiving from the US when it visited us and lectured us on topics has now been dropped. And it's a much more collaborative approach, much more reflective probably of the future importance of the African continent going forward. So I think when we talk about education, I think we should not be assuming it's only inward looking. I think there are a number of other people who probably need to rethink their own roles in history. That's just my personal view. I think there was another question, but Professor Luke, you've answered it. So now you've taken away my job as moderator. I don't actually have any further questions. Is there a new question on the link?
Aisha, you have a new question.
Excellent.
There's one directed to Dr.
To Dr. Nasser and Professor Won. So this question is, how does the AfCFTA complement existing intra-African regional trade agreements? Are there any conflicts? And if so, how are these being overcome or proposed to be overcome in the treaty? Maybe Professor Won, you could start us off.
So my sense is, and I'd like to start with a disclaimer, that I'm not a trade expert, I'm an investment law expert, but my sense is that the treaty itself contains provisions that address these kinds of possible inconsistent application of overlapping treaties. So upon ratification, there are provisions that prevail over existing obligations, and there are those that continue to exist. So I think it's a very technical question, but I think if one has to be guided by any one of these overlapping regimes, you have to just look at the provisions and make sure that which one prevails under what circumstances, and temporarily also up to what point.
Okay, thank you. So a typical lawyer's answer of it depends. And also, we know who to consult in those very difficult technical questions. Dr. Nagla, what do you think?
To add, really, I have nothing to add.
Professor Emilia, do we have any more questions?
No, there's just a comment in the chat from Usa. It says one of the main criticisms of AfCFTA is that although it provides a mechanism for the settlement of disputes among its member states, but it does not for private entities who will engage in actual trade in goods and services and investments across Africa. How will the esteemed panelists respond to this criticism?
I think Professor Luke has volunteered. Your hand is up. Was that conscious?
No, actually, I put my hand up to pick up on another point that was made, but not so much to respond specifically to this. So let me not preempt you as chair to perhaps direct that question maybe to another colleague.
Does anybody want to field that question? Or, I mean, it's really a comment on.
If I understood the comment or the question or comment/question correctly, the dispute resolution mechanism in the free trade agreement applies only to state-to-state dispute, and it does not address a private cause of action or does not offer an opportunity for private actors to access that dispute resolution mechanism. And I think structurally it has to be that way. This is an international treaty, and of course the treaty binds states, and unlike investment treaties whereby the possibility of a private cause of action against the state exists, in trade that doesn't. So it is necessarily limited to state-to-state dispute for violations of the treaty provisions. So there needs to be another mechanism of dispute resolution for private actors. And of course, there is no analogous provision in trade law as it is in investment law. So that's what I.
May I add, this state-to-state dispute resolution is the very same thing in the WTO. So if you as a company have a big claim against another state, you take your dispute to your state, and the state triggers the process and started against the state to which the other company belongs to. So it's not totally, individuals are not totally eliminated from it. The problem here is that you have to really convince your state that there is a case for you. And of course, here again, political elements will interfere, but that is the case with most international treaties, you know, because they are treaties among states. Of course, we can borrow from this, and that's what I've been thinking about. We could create a system, something in between the exit convention, where the individual companies have direct access to the system, and the WTO, where it's only the states. That will need slight modifications to the provisions here. And that's what I had in mind when I was speaking, that practice will let us know how to update this good piece of work. It's a really good piece of work, okay? But I mean, you can't imagine that people sitting, negotiating and drafting in rooms would be able to conceptualize or foresee all the practical problems. But definitely this is one of the problems. And I think though it's clear that the intention to the dispute mechanism is only for states, but by some interpretation, we could create a mechanism where individuals could have an access and end up with something in between exit and the WTO. And that would be great if they can update the treaty in that way.
Thank you. I don't know if
yes, Chair. If I could come to the point that I wanted to make earlier, and it's to pick up on what you said about how external partners are now trying to take a much more respectful approach to their continent and so on. And I think this does have bearing on trade policy in one important respect, which could also affect how the AfCFTA is implemented. And that is where you have a situation of asymmetry in economies. At what point do you enter into reciprocal trade agreements with the partners that have economic asymmetry in relation to your own economy? And that is a very difficult question, which I've started working on. And so I don't have all the answers right now, but in my view, what I see emerging is some advanced economies trying to already put in place reciprocal arrangements with African countries. Kenya signed a free trade agreement with the UK. Ghana has done the same, and so on. Mauritius with China. Kenya has been strongly advocating for an FTA with the US, and so on. And I think that this kind of approach is probably premature for our economies, where if you look at least economic history, when these advanced, these countries that are now have advanced economies were growing, they did so by not having these sorts of open agreements so that they could develop their own industries, develop their own productive capacities. We've been talking about capacity building and so on. I was just wondering whether, there isn't a case for African countries, which, collectively we account for only 3% of world trade at this time. I think there's a case at the WTO for us to have trade agreements that do not require reciprocity until at least a transitional period for the AfCFTA to be fully implemented. Now, because African economies are all, African governments are all looking for advantage, to move very quickly, to attract investment and so on. I know that there is not agreement on this at the AU at this point in time. There was a proposal that African governments should not enter into third-party FTAs, but we can see that that is not happening. So I think this is an important issue, which perhaps the onus should be on the partners to themselves show some restraint and give the continent some time to build up its capacities before engaging in these reciprocal agreements. I don't want to take up too much time, but you can see where I'm going, and that is that we have seen analysis that have shown that if we don't give ourselves the space to develop productive capacity, we'll be flooded with goods from other countries. And we are seeing this happening already. I don't want to point fingers anywhere, but you just look at the African markets, look at the imports, just look at the range. At what point will we start producing these things ourselves if we're engaging in these reciprocal agreements with economies that are asymmetrical in their structure compared to ours? So I just put this out there because I think that's also an important part of the conversation. The US, I should say, at least in AGOA, has given Africa, except for the conditions relating to governance, free access to their market without at this point requiring reciprocity. But this is something that I think we should pay attention to because it could affect whether or not we do indeed see the benefits that we expect to see from the AfCFTA. Sorry to take up so much time, but I thought I should just put this out there. Just watch out, there'll be some more work coming from my shop on this issue in the not too distant future.
Thank you for those comments. I think when you were talking, it occurred to me that obviously as Africa is trying to integrate, there are other nations who have other pressures that they're facing. So the UK has obviously a lot of pressure in building its own, bilateral and multilateral treaties now to replace the ones it's no longer a part of. And I think that explains some of what has been happening. I think the other thing that occurred to me when you spoke is that I don't know what panelists think about this. Often African member states see each other as hostile and rivals in a way that they don't with outsiders. And that may explain why they rush to have direct agreements rather than waiting for the continent to come together. For some of them, they may feel that actually they're able to negotiate well for themselves and that the group will slow them down. I don't know what people think about this, but before I open it up to your comments, I just wanted to mention that all of the audience should be able to see a very short survey, which we'd please ask you to complete before the session ends. Thank you. Did anyone want to comment about this idea of competition as between Africans?
That's what I said. This agreement could be the triggering tool or instrument to level the ground and turn African countries instead of competing to complement each other. And this is part of our colonial history. I mean, it's well, the English saying divide and rule, okay, is I mean, it was their policy for a long time. And that's why education is important to change all that. So I think if you couple education by will of power to overcome that, we can overcome it. It will take time, okay? But instruments like that will help put inside us the feeling that we complement and not compete with each other. That's all what I have to say.
If I may add to that, Aisha, I think the role of continued economic dependency should not be underestimated. An excellent example of this is what Professor Luke has just mentioned, the AGOA unilateral concessions. Unilateral concessions are tricky because they are revocable at will, and they could be revoked at a time where you most need it. They create dependency, and then of course they are gone. And a good example is what happened to AGOA to Ethiopia recently. The United States has decided to retract the AGOA benefits, and I've been reading reports that immediately thousands of workers have been displaced. And it's in the legislation itself, it says it's a foreign policy tool that is used to basically coerce these developing countries into performing certain acts. So the continued economic dependency is what creates all these problems, including the potential rivalry among African states. So I think that's the component of, and it's been described as in many different types of ways, but that I think is the most serious problem.
Gregor, did you have anything to add on that issue?
No, I think my fellow panelists, that they responded very comprehensively.
Okay, I think, I mean, just to round up, there's obviously a lot has been said about the challenges the continent is facing. I think it's, you know, we have to give credit to the progress, I think, that has been made. I think, you know, sometimes when you focus a lot on challenges, you forget to give yourselves a clap for what our governments have done so far. So if you look at the Europeans, they took 4 decades to negotiate and enter into a treaty. I mean, we are doing this in COVID circumstances, under extreme pressure, economic and political, in a very short space of time. And I must say, as an outside observer with limited information on the process, I am slightly surprised at how quickly these protocols are being negotiated, given how the diversity on our continent. I mean, it's no joke to be bringing 54 countries to the table. So I feel like we should give credit to our governments for, at least in terms of aspiring to unity. I think we all know unity is actually a very difficult thing to achieve and to keep together. I don't know what other panelists feel about the progress that is being made and whether it is fair in our circumstances.
Maybe I could step in just very briefly to say that, Aisha, I think you're quite right. Much is being done. This is, again, the driver of all of this is that our entrepreneurs, our youth, investors are really pushing for these changes to take place. And as I said earlier, government is really playing catch up because, you know, what's happening on the ground is far ahead of the regulatory framework that is in place. So yes, indeed, I think we should congratulate ourselves, but we should not lose sight of the goal of economic transformation on our continent, because that is where we want to, the destination we want to arrive at, and we can only do this ourselves. It's, you know, as we've just seen from the comments that were made in relation to the, you know, economic dependency and so on. There are so many other interests that are at play, and we just need to be focused on what our objectives are and the means of achieving them.
Thank you. I think Professor Emilia, at my end, we'd like to thank you for the time you've given our panel. I think we had a very interesting interactive discussion. I think we also as a panel highlighted the challenges of sometimes communicating across continents. So I don't know if you wanted to have some closing remarks or introduce the new panel. I see that a lot of people have now completed their survey. I just wanted to thank everyone.
Thank you very, 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 very much, Aisha and your panelists. Thank you. Thank you, David. Thank you, Juan. Thank you, Gregor. Thank you, Nagla. It's been an amazing introduction. So people are very excited. I've been receiving messages that this is a fantastic panel. The pace, I thank you very much for the pace. You took it easy so we could understand what you were saying, because you're discussing a very, very technical and tough issues, and we were able to follow. So thank you very much for that. As you can see from, I don't know if you can see the poll, we've had the polls and with the results, 100%. So we've got 77% of our attendees answered the poll. 100% said that the speakers clearly addressed the topics. So it is tough to get 100% in an exam. Well done to all of you. Juan and David, they're smiling as academics like me, so they sort of know how tough it is to give a student 100%, but you got 100%. Then the second, you also got 100%, where it says, were the topics useful for your practice and education? And 100% said yes. And I think that's really important because we want to be sure that what we discuss, our attendees actually find them useful. The third one, as you can imagine, which has nothing to do with what you're doing, we asked, do you think the Africa Continental Free Trade Area Agreement will drive development of African states? You also got a distinction, so you managed to convince a lot of us. 92% said yes, 8% said no. So you still have a little bit more work to do because we want you to have perfect scores of 100%. And that brings, that's the end of this panel. Thank you so very much. Before we leave, I'm going to ask Stephanie to come on and share a little bit on the greener arbitration so we know what's going on. We have to do our bit for the environment. We've been hearing about the environment. Nagla is particular about the environment, that we have to behave ourselves. So Stephanie is going to tell us what we can do as dispute resolution practitioners. After Stephanie speaks, we would have a lunch break. So remember that we're meant to be in Casablanca. So and eat couscous for lunch. That's the best place. Morocco is couscous. So try and grab some couscous for lunch. And then we'll come back at Casablanca 3 p.m. And so I'm going to hand over to Stephanie to tell us about greener arbitration. Stephanie, please.
Great, thank you, Amelia. I'm just trying to share my screen. Let's see. So I'm having a few technical issues this morning, but you just bear with me.
We can see your screen. Yeah. Okay.
Okay. Great. Let me just move this one across. There we go. Very beginning. So hopefully you can all see the kind of introductory slide. So hello everybody, good morning, good afternoon, good evening, depending on where you are. Thank you very much to Amelia and the organising team for providing a space for the campaign for greener arbitrations to present at this notable event. So my name is Stephanie Mbonu, and I'm a member of the International Arbitration Group at Freshfields based in London. I'm also a co-chair of the Africa subcommittee of the Campaign for Greener Arbitrations, and I was also a member of the inaugural wider steering committee of the campaign. On the slides, on the screen in front, you can see that that Abiyomi is also one of my co-chairs. Shireen was one of the original co-chairs, but she is no longer a co-chair because she has lots of other important roles on the steering committee. So in the 10 minutes or so that I have to speak to you about the work that I'm doing, I'm not going to be held responsible for keeping anyone from their lunch, because this sounds delicious. I'm going to speak to you for the next 10 minutes or so about the campaign for greener arbitrations and the work that we've been doing for the past year or so. So as the name suggests, the campaign is an initiative to reduce the environmental impact of international arbitrations. It was founded by international arbitrator Lucy Greenwood in 2019 with the aim of significantly reducing the carbon footprint of the arbitration community. In 2020, the Campaign for Greener Arbitrations established a steering committee comprised of members of the arbitration community, including practitioners, institutions, and legal service providers, who each have a stake in the continued improvement of international arbitration. A fundamental objective of the steering committee was the establishment of a framework and a set of protocols to promote better environmental behaviour through a series of action items. The protocols serve as practical guidance for implementing the tenets of the guiding principles. So our working group was formed in early 2020 with the goal of developing practical steps to accomplish the campaign's guiding principles as outlined on the screen in front of you. So we sought to create a concise set of directives to guide members of the community in an effort to reduce the environmental impact of international arbitrations and also domestic arbitrations. So as mentioned, the working group began work in mid-2020 and essentially considered all aspects of international arbitration. So we looked at, the roles played by arbitrators, roles played by counsel, institutions, and vendors. The working group examined behaviours throughout international arbitration cases. They also expanded their review to conferences and practices at firms, chambers, and institutions. And in doing so, they identified a number of areas where each of the stakeholders within these groups could significantly improve and adjust their behaviours to reduce the environmental footprint. Following a public consultation period in early 2021, the campaign launched on Earth Day earlier this year in April. Its suggested framework and 6 associated protocols. So we started our work just as most of the world was shutting down due to the pandemic. And it really was compelling to be working on this initiative whilst viewing images like the one here today. I'm sure that many of you have seen similar striking visuals, perhaps showing the only highlight of our lockdown, which was the immediate reduction in pollution. And so I'm essentially sharing this image today as a reminder that our actions have immediate consequences. And I think, as we begin to emerge and approach a hopeful time and begin our new normal, whatever that looks like, wherever you are, I think that now is perhaps the perfect time to consider implementing changes to our working environments rather than simply returning to the status quo. So the three main areas that the campaign's work focused on, as you can see from the screen, adopting clean forms of energy, reducing the use of long-haul travel, reducing waste, for example, by eliminating hard copy filings altogether. And so the campaign's research has shown that focusing on these three critical areas will have the largest impact of reducing our carbon emissions. And I will put a link to the protocols and the framework in the chat. And so, when you have the chance to review the protocols, you'll see that practical steps to address each of these three areas are contained throughout all of the protocols. So just a very, very high level overview of what the protocols are. You can see them on the screen in front of you. So our initial work focused on the conduct of arbitral proceedings, and we considered several approaches for additional protocols, with the ultimate decision to address specific stakeholders. The final result is our collection of 6 unique yet related protocols that propose sustainable measures. Each protocol is intended to be adopted individually or in combination as appropriate. So as I mentioned earlier, we carry unifying principles throughout all 6 protocols. The areas listed on this slide are repeated with some variation and additional instruction throughout most of the protocols. We identify practical ways to adhere to the sustainable measures listed here, including the main areas of travel, clean energy and waste reduction, as well as other social responsibility considerations. And so earlier this year, various subcommittees were launched. As I mentioned, myself and Abiyomi co-chaired the Africa subcommittee, but I also wanted to take the opportunity today to introduce you to other members of the Africa subcommittee. So if you are interested in learning more about the work of the subcommittee, or ways in which you may be able to get involved, then please do reach out. So if I just scroll through the next 3 pages, we have quite a few members, some of which I'm sure are actually in attendance at today's conference. And so over the next 12 months, the aim is really to move from commitments to principles, to concrete steps and actions. So in addition to implementing the green principles, our aim is also to advise and equip users with the tools to implement the aims of the campaign. So some of the things that the campaign is carrying out are further environmental impact analysis. It's just so we can have more of an understanding about, in reality, what is the impact of our arbitrations of different sizes and formats. For example, if I was to print 5 hard copy bundles, what are the carbon emissions from that printing? How many trees would I save if I decided to opt for an electronic hearing bundle as opposed to a hard copy hearing bundle? And so, as mentioned, please do get in touch with myself or other members of the Africa subcommittee if you would like to know more. As I'm sure some of you would have seen on LinkedIn, we have started to promote the work of the Africa subcommittee. So please do follow our Africa subcommittee LinkedIn page. Yes, and thank you again for inviting me to speak today, Emilia.
Thank you so very much, Stephanie, and thank you for keeping us informed on what's going on. In the chat, I have put the link, I put in English, Yasmin put in French, the link for colleagues to sign the Green Pledge. And that way they would also see the website and keep abreast of the work that is ongoing. Thank you, thank you, thank you. Thank you very much. Thank you, Aisha. Thank you, David. Thank you, Nagla, Gregor. One, you can now go back to bed. Go and get some sleep. Thank you so very, very much. We will now pause and for you to go, make sure you eat couscous. I'm actually going to ask you when you come back from lunch if you ate couscous, because if we were in Casablanca, we will be eating couscous. And so eat something and then we would reconvene in another 1 hour, 2 hours. So well, 3 p.m. Casablanca time. So that's in 2 hours time. We're actually less than 2 hours. We've taken 10 minutes from your lunch break. Okay, thank you very much. Please go and grab something to eat. Bye, everybody. See you later.